Hello? Hello? Is this thing on? Hi, guys. Happy end of the holidays and Happy New Year. Say me. How you guys doing today? Gosh, my earbuds keep falling out. Let me know how you doing. Where you watching from? What's going on? I am wearing this outfit as a disguise out of sheer embarrassment for my football situation today because I am one of those people. I'm an Ohio State fan. Hello, maybe. Hello, my wonderful mod. How's it going? All right. This is Criminally Confident. Welcome. And we had quite the stream yesterday. And by that I mean we are very excited to be moving forward in this trial. So I would greatly appreciate it if you could go ahead and give this a thumbs up by liking the stream and making sure that you are subscribed to my channel for this trial, for future trials, and for future live trials that I will cover. That would be greatly appreciated. I am trying to think of what else I want to cover. I have my lipstick on that I put on during the stream yesterday. Do you see it? The remnants of it. Yeah. I just got a look of myself. And yes, I am on the lam. I am on the lam from shame. Someone help me. How do you handle losses like this? This is awful. And my like CIA earbud thing is just really tripping out today. It does not want me to have a happy new year. So I'm just gonna go ahead and put it in my other ear. We're just gonna go that way. All right. I think I hear better out of this ear anyways. Okay, so I go like this. Stick with me, guys. Certainly my earlobes aren't that big. Okay. Still not working, but we are going to proceed. How are you guys doing? Yeah? Did you see anything crazy last night? Did you hear about what I saw last night? I saw these two women start to fight. And apparently my husband heard it and he looked back to make sure that I wasn't involved. Like, what? And he said all he saw was me standing next to the Keno machine, ironically, which is where this all went down. And I was air pumping. I was like, ah, these ladies are gonna fight. So I apologized to the owner of the bar and I was like, I'm sorry that I use your facility as my personal jungle gym. And I'm just, patiently waiting to perform a to relieve a tension pneumothorax on someone someday in the wild, and that seems like a good opportunity, even though I've been told specifically by said bar owner that if he's dying on the ground, he does not want me to touch him. baby's broken. Yes, I saw the message that she fell. You fell over your dog, which is like, I think has to be the #1 cause of like broken hips in America. I'm not gonna lie. I don't think it's ice. I think it's falling over your friggin' dogs. Can we just like percolate on it for a moment? Like, why are they always trying to kill us? We're just trying to make their lives great. We're trying to give them yummy food and treats, and they're just like, here, let's see what I can do. Look what I can do. And tripping you down the stairs and just making a fool out of you. It's a sham. I think my cat is definitely at fault for this. I don't know about you guys, but my cat is the one in the house who tries to kill us every day. Anywho, I went on Shizzy's stream last night. That was fun. I watched the game. That was not fun. Why? Oh my God. I just realized I'm wearing Miami colors. Also my alma mater's colors. We actually won our bowl game, by the way. We actually won our bowl game. So there's that. All right. Have you guys eaten your sauerkraut today? Your sauerkraut and oranges and like any other weird ass traditions? Let me know. I need as much good luck this year as I can possibly get. So whatever weird traditions I can do on stream, just let me know. I feel bad. Maybe you have to like, most importantly, mod for me and then take care of everything else in your life. Kidding. You guys, I'm kidding. I'm hilarious. I'm hilarious. This is who I am. This is who I am. I am hilarious. In 2026. And I talk with a light lisp. No one's talking. What is wrong with you guys? Okay. All right. Well, I guess that means I can start the trial. We are officially opening for the defense. So that's going to be interesting to see what kind of concoction they're throwing in a skillet to try to get their client off the hot seat. Okay? Okay, soldiers. How do I do this? Damn it. There it goes. Oh, and if you haven't liked the stream and subscribed already, it's free. So please don't be an asshole in 2026. Thanks. Bye.
Erardo, Bloise, last name, Bloise, Bloise.
May it please the court.
You may proceed.
Mr. Rain. Good morning, ladies and gentlemen. Good morning, Mr. Bloise.
Good morning, Counselor.
Mr. Bloise, we've already know you work as a crime scene investigator for Orange County.
Money.
Okay.
Yes.
And rather than go through your qualifications, I'd like to just jump right in if that's okay.
Okay, no problem.
Sir, on Wednesday, July 23rd of 2008, you were asked to inspect a vehicle. Were you not?
Wednesday.
Yes. If you want, you can refer to your report.
Say Wednesday, July 30th,
23rd.
23rd.
Yes.
Why is everything so loud? Why are colors so bright?
Yes.
Okay. And who did this car to?
Anthony Lazaro.
Okay. And what you did at this time was you did a vehicle inspection of the exterior and interior of the car.
Correct.
Okay. And part of that was you also wanted to check the car with an alternating light source.
Correct. Yes.
Okay. And you also did a presumptive test for blood, did you not?
Yes, I did.
Sustained, rephrase the question.
Can you tell us everything you did with that car?
I inspected the vehicle exterior, interior, and also I checked the trunk area, and I observed some stain on the carpet. Before that, I used alternative light sources, give me a positive reaction for stain. Next step is I use a presumptive blood test in that area,
It
and
makes me
the
want to
result was
listen to the
negative.
salsa music.
Okay. And is it your experience that the alternating light source, the purpose of it is to tell you where to look further?
Yes,
Okay. So it's just basically a tool that people's cars have stains, and that's where you should look.
stain.
How does the alternate light source assist you?
The alternative light sources is tools that we have in order to detect any kind of reaction for body fluids.
Okay. And then your next step would be to do what?
What?
Next step, if I observe any suspected stain, I proceed to do a presumptive blood test.
Okay. And you did that, and what were the results?
Negative.
Okay. And you also then did what next?
After that inspection, photographed interior, exterior of the vehicle, and that's it.
Okay. Did you place the car on a lift at all?
No, I did not.
Okay. And can you check your report and see if there was anything else you did?
Yes, I did, but this is the other vehicle.
Okay.
That was the Sunfire vehicle.
But you didn't indicate that on your report. So I just wanted to clear that up, right?
Dios mío.
Yeah, in the auto death garage, I mentioned at 16, 13 hours that I moved the vehicle from the forensic garage, which was the white Pontiac, to the lift.
Okay.
Yes, it is in my report, but I don't mention the
You don't mention which vehicle.
back number exactly. Yes.
Okay.
Lo siento.
Now, did you collect any items from Tony Lazzaro's car of evidentiary value?
No.
Okay. Now, I'd like to take you to August of 2008, August 6, 2008. Can you tell the ladies and gentlemen
Why?
of the jury what you did on that day?
August 2008.
Yes, August 6, 2008.
May I refer to my report, please?
Yes, you may.
Your Honor. Thank you, sir.
Oh, Your Honor. Mm-hmm.
That was a search warrant
Okay. And where was this search warrant executed?
at the residence of the Anthony's family.
Okay. Would that be the home on 4937 Hope Spring Drive?
Yes.
Casa de
Okay.
Anthony.
And what was your assignment to do that day?
And that day, that was to check the bedroom belongs to Casey. Bedroom belongs to Casey, and then to check for clothing, and inspected clothing with using ultralight sources, and then collected some pieces of clothing from the bedroom.
Was part of your assignment to search any other rooms?
No, to my best recollection. The only things that we checked was the living room area and the garage area, the car, the vehicle, and that's it.
Okay. Did you check George and Cindy Anthony's room?
I just did visual inspection. I don't remember if I used any kind of light sources to my
Okay.
best recollection.
But you did do a visual inspection of.
Hello, mate.
Did you? Oh, excuse me. Let me strike that. You did go further in Casey Anthony's room.
Yes, correct. Yes.
Okay. I'd like to show you a series of photographs identified as Defense Identification Exhibit X, Y, Z, AA, AB, AC, AD, AE, AF, AH,
Hello.
AG, AI, and AJ. May I approach the
How
witness
was the
here?
evening?
Showing you now. I'll speak loudly. I'm showing you now Defense Exhibit X. What does that appear to be to you, sir?
That was the bedroom,
Who's better?
Casey.
And is that a fair and accurate representation of the bedroom as it appeared on that day to you?
Yes.
Unless there's any objections, I'd like to move Defense Exhibit X into evidence.
You
I'll
know.
do the series of photographs I have objections to. remember, if you don't have microphones on the court report, do you want to log in, Mike, Mr.?
I'm actually gonna go back.
Okay. State had no objections to that exhibit?
Correct, no objection.
Okay, it will be received. Did you give it back to the clerk?
Yes, sir.
It will be received in evidence as defense exhibit numbered.
Your Honor, in light of the states agreeing on these items, I'd like to just go ahead and enter them all into evidence, if I may.
State, any objections?
No, I've reviewed them all. There's no objection.
Okay, they will be removed. They will be received in evidence as the next announced exhibit numbers. Please hand them to the clerk so she can mark them and announce them.
Exhibit number 13.
May I publish Defense Exhibit 2 to the jury, Your Honor?
Yes, you may.
Make sure to subscribe to Lefty, please, so I don't have to
Yes.
come and find you.
Yes, sir.
You.
How do I see it? All right, got it. Okay. Sir, can you see the photograph?
Yes.
Can the ladies and gentlemen of the jury see the photograph? Okay. Now, sir,
Oh,
can you describe the room basically for us?
It's a single bed and some pillows on the bed, nightstand, a dresser.
What is this item here?
mi amigo.
It's like several pictures.
Okay. And what would be behind this wall here?
The closet.
Okay. And tell us what your goal was to do that day. What were you there to do?
In that day was to collect some pieces of clothing from the closet and
Zapatos?
check those items at the bathroom with the alternative light sources, and then collect the clothing, the pieces of clothing.
Okay. And was it your understanding that you were going to look at the clothing that
Like it or hate it.
had, well, let me rephrase that. Was it your understanding that you were going to now look at all of Casey Anthony's clothing?
Yes, just to check the bathroom. Yes, clothing.
And what was your goal in looking at all of her clothing?
My goal is to inspect the items with alternative light sources. If I see any suspected stain, and then collect the items that I observe some suspected stain.
I knew
Okay.
you were going
And
to
tell the ladies
immediately
and gentlemen of the
notice
jury how you go
that.
about doing that.
I just put some black cover on the window
Why do you do that?
in order to get the room dark, and then use the alternative light sources, which give me some fluorescent light. And then when I inspected the clothing, I'd be able to see any suspected stain. And then if I see any suspected stain, and then I separate that item and put in the paper bag, and then collect as evidence.
Okay. Let me take you step by step if I can.
Viva?
What is this photograph that you're looking at now?
That was the closet.
Oh my God, another case with a closet coming off the Jody
Okay.
trial.
And that is that where you got all of the clothing from?
Not all of them, some pieces of clothing, yes.
Okay. And you also checked the drawers in the room?
I don't recall if I checked the drawers.
Do you believe you would have done a thorough job in checking the entire room?
Yes.
Okay. And
You can't click mine or maybes
I'm going
link.
to show you some clothing.
Double check.
I'm showing you now defense evidence 5.
I heard
Is that
so
one of the
bad
items that you inspected?
Yes.
from screaming at
Is that one of the items that you had found a suspected stain on at all?
Let me check
right.
the tag
Sure.
because it's
No
have
problem.
an ID on it. Number 1, Your Honor, may I refer to my report to refresh my recollection? Thank you, Your Honor.
I'll come
That
back,
was
just give me a
the
minute.
charcoal gray pants, brand name Sync Site 5, tag number H52175. I checked the item with ultralight sources. No stain was found.
Dios mío.
Was it your understanding that these pair of pants were the pants that Casey was seen wearing on June 16, 2008?
I was informed that she was wearing that pants, yes.
Okay, and you found no stains on those pants.
No.
Now, I'd like for you to describe exactly a little bit more of what you did. You put black paper on the windows, correct?
Correct.
And the purpose of that was to make the room as dark as possible?
Yes.
Okay, and then what do you do when do you take one piece of clothing at a time and inspect it, or how does that go?
One piece at a
Okay.
time.
Okay, and do you photograph certain stains as you see them?
Yes, I did.
Okay, and I'm going to show you Defense
Oh,
Exhibit
something cracked.
14.
Whole bunch of things cracked.
Is this what the stains appear to you under the alternating light source?
Yes.
Okay, and you photograph them to document them, I presume?
Yes.
Okay. Now, when you see something like that, that's, I guess, pants, a stain on the bottom of someone's pants, correct?
Yes, look like, yes.
What do you do with an item like that?
As soon as I observed that kind of stain, what I did, I submit those items to the FBI lab.
Okay. And
The
that
FBI
would
lab.
be a large stain under yours. Well, I'm sorry, I don't mean, describe to us, would you consider that large, small? How would you describe that?
You can say like a medium
Okay.
stain, yeah.
I'm going to show you now Defense Exhibit 12. And is that another example of another piece of clothing?
Is it hot
Yes.
in here?
Okay. And what are we seeing here, sir?
In this picture, you can observe some scales and arrow that shows the indication that I found some stain.
Now, would you classify those as small stains?
What?
Yes.
He is not a stain expert.
And-
or-
These are the types of details that you're looking for, are they not?
Correct, in clothing, yes.
Okay. And do you even get more detailed than this as far as stains are concerned?
No, that's
Okay.
it, just stain like that.
Okay. Okay. After you have inspected all of her clothing, what did you do next?
Then I proceed to packaging in every single item in a paper bag and submit it to the FBI lab.
Now, when you do this inspection, what kind of protective gear are you wearing?
Was wearing the lab.
Hey, if you just got a membership from Maybe, make sure to say thank you. Also, throw some W's in the chat because that was awfully gracious jumping into 2026. Thank you so much, Maybe. You are so important to this channel. We love you. And welcome to everyone who just received a membership. The more you chat, the more likely you are to get a gifted membership. So, okay.
Tyvek.
Okay. What is that?
It's like a jumpsuit.
Okay. And does that have a hood or anything like that?
No.
Okay.
Just
What
Tyvek.
about-
And clothing, I mean gloves.
Okay. So you have gloves on, you have a white jumpsuit, is it?
Yes.
And what about foot protection? Anything there?
No, it's in the lab,
Okay.
in a forensic lab.
Any hair nets or anything to prevent your hair from falling on?
Hair nets, I use hair nets, yes.
Okay. So you're in full gear.
Yes.
And do you speak while you're doing these things?
No.
And why not?
Huh?
Why not?
Because I by myself.
Okay. You mean you don't talk to yourself? All right. Now,
Getting so many
let me ask you this, Mr. Blaze.
Guys,
Was Alina Burrows with you?
Excuse me. Yes.
Okay. So did you talk to her while you were doing this?
Oh,
no, it's make believe.
if you refer to this picture,
Yeah.
I took those pictures in the forensic lab.
Okay.
Okay.
So,
I'm by myself.
okay. So if we're all to understand what you did, you inspected the items in her room and then decided which ones you were going to take. Is that correct?
That's correct. Yes.
Okay. And then you went to the lab and you photographed them like this so we could see.
Correct.
But while you were doing this in Casey's room, you were also with Miss Burrows, another CSI person.
Yeah, she was with me.
Okay. And was Detective Yuri Melich with you as well?
Yes.
Did he go in the room or was it just the crime scene investigators?
No, he spent some time with us inside the room. Yes.
Okay. So he was made aware of all that was going on and all that was being taken from the home.
Yes.
Okay. Was there anything else you did in regards to this search warrant?
That's it. That was my whole involvement in this search warrant.
Okay. And then part of your job at that point would be to do what with the information, what with these items of evidence?
Submitted to the FBI lab.
Okay. And how is that done?
I just photographed the items,
Same.
prepared the letter to the FBI lab with the pictures that I observed a suspected stain, and submitted with the property forms that we have as an agency, as the Orange County Sheriff's Office property form, and then submit the items to the FBI lab.
And are these items of evidence protected in any way from further contamination?
Yes,
How so?
it's a paper bag. I seal it and put my initial on it.
Kind of like some of the bags that we see here today?
Yes, sir.
Okay. I have no further questions.
Why was this the defense's
Cross-examination?
first witness out of everyone? Why was that the first? What was he doing?
Investigator Bloisey, the scope of the search warrant that you were just speaking of was to locate clothing items of Ms. Anthony's only, correct?
Just my best understanding, yes.
And it is also your understanding that the pants that you were looking for as perhaps a garment that Ms. Anthony wore on June 16th of 2008 had been washed by her mother.
Yes, she informed me that she washed the particular item. Yes, she did.
When you inspected Tony Lazzaro's Jeep, you recall
Yes.
doing that?
Yes.
The yeep.
Did it smell like there'd been a dead body in it?
No.
No further questions.
That's what my ex-boyfriend used to call
Redirect.
the yeep. The yeep. Silent. J. He.
When you inspected Mr. Lazzaro's car, did you find a bag of garbage that had been in there in the trunk for 3 weeks?
No.
No further questions.
This is
May the
petty
witness
as
be
hell.
Thank you, sir. You may be excused.
Thank you, Your Honor.
Thank you. Well, he was an absolute freaking delight. And Wilhelmer Media. Always in with the win.
My name is Heather Subert. Spelling of my last name is Seubert.
Good morning, Ms. Subert.
Good morning, sir.
Can you tell
agree.
us what is your occupation?
I am currently the unit chief of the Firearms Tool Marks Unit at the FBI laboratory located in Quantico, Virginia.
Okay. And in 2008, what position did you hold with the FBI?
In 2008, I was one of the supervisory forensic DNA examiners in the DNA analysis unit, also at the FBI laboratory.
And how is the DNA analysis unit broken down at the FBI laboratory?
Well, currently there are actually three DNA units. There is the mitochondrial DNA unit, the nuclear DNA unit, and the federal DNA database unit.
Okay. And could you give the ladies and gentlemen of the jury just a brief synopsis of what each unit does?
Sure. In the mitochondrial DNA analysis unit, that unit's responsible for examining items of evidence for mitochondrial DNA typing. And the types of evidence that they receive are typically samples, bone, hairs, and teeth. In the nuclear DNA unit's responsible for also examining items of evidence for the presence of biological fluids such as blood and semen, and then examining those stains for processing them for DNA typing. And then in the federal DNA database unit, that unit does not receive any items of evidence. Its mission is to process samples from known convicted offenders for entry into the National DNA Index.
Okay. And how long have you been employed with the FBI?
Just about 12 and a half years. I started in October of 1998.
And with whom were you employed before the FBI?
You have a good
I was employed
name,
with the
buddy.
Department of the Michigan State Police as a forensic scientist in the forensic laboratory located in Lansing, Michigan.
And what is your educational background?
I've received a Bachelor's of Science in Forensic Science from Michigan State University located in East Lansing, Michigan.
And have you taken any additional coursework in the area of DNA analysis?
Yes, I have. I'm actually currently enrolled in the graduate program at the University of Florida out of Gainesville, Florida, in a master's program focused on forensic DNA and serology. And I've also taken coursework through the George Mason University, which is located in Fairfax, Virginia, in the areas of statistics and genetics. And I've also taken a molecular biology course from
looked at
Lansing
their
Community
law
College,
program.
located in Lansing, Michigan.
And have you taken any specialized training while employed with the FBI?
Yes, I have. I actually started as a biologist in the mitochondrial
Wow.
DNA analysis unit when I started with the Bureau in 1998. And so I was trained and qualified as a biologist. So I had undergone a specialized training program to perform DNA typing on bones, hairs, and teeth. And then I was promoted to a forensic DNA examiner in 2001. And as a part of that program, or that position, I was trained and qualified under the supervision of a qualified DNA examiner to perform those job duties. And then I had also spent time in the federal DNA database unit, so I underwent a truncated training program to be a qualified database examiner as well.
And could you tell the ladies and gentlemen of the jury what is serology?
Sure. Serology is the science involved in identifying biological fluids such as blood, semen, and other biological fluids.
Okay. And have you received any training in serology?
Yes, I have. When I started with the Michigan State Police, I was devoted most of my time as a serologist in that position. And so I was trained and qualified as a serologist to examine items of evidence for blood and semen. And then when I started in the DNA analysis unit as an examiner, I also, as a part of my training, underwent some serology training there as well.
And have you done any teaching or public speaking in the in the fields of forensic science?
I have. As one of my job duties with the FBI was one of the primary instructors on the FBI's quality assurance standards. And so I did that for a number of years and probably provided instruction to well over 1,000 DNA analysts on what are termed as the quality assurance standards, which laboratories performing DNA typing and entering DNA profiles into the National DNA Index have to comply with. And so I provided instruction on that for a number of years. And I've also presented at conferences in the area of the quality assurance standards, and provided also specialized topics in DNA at conferences as well.
And are you a member of any professional organizations for forensic
Come on,
science?
Baez.
I'm a fellow of the American Academy of Forensic Sciences. I am currently one of the proficiency test review members for the biology section for the American Society of Crime Laboratory Directors Laboratory Accreditation Board. And I was the vice chair of the scientific working group on DNA analysis methods, but I retired from that position in January of this year.
What does that mean, the scientific working group for DNA?
Well, the Scientific Working Group on DNA Analysis is a group of individuals from many different forensic laboratories across the United States and also internationally that are devoted to discussing current topics in DNA and setting guidelines, as well as managing the quality assurance standards for forensic DNA testing laboratories and DNA database laboratories. And they meet twice a year, and they're responsible for issuing documents for forensic laboratories and database laboratories to use in their analysis.
Okay. And have you testified as an expert witness in serology and DNA in the past?
Yes, I have.
Where and how many times?
Since I've been with the FBI, I provided testimony 18 times and have been qualified as an expert 18 times in the area of DNA and serology. And the federal court systems that I've been qualified in have been Washington, D.C., Albuquerque, New Mexico, Oklahoma, Kentucky, Louisiana, Michigan.
Would that be all across the country?
Yes, sir.
Okay.
Sorry.
All right. Your Honor, at this time, I would move Ms. Subert to have her admitted as an expert in serology and DNA analysis.
Okay, please.
State absolutely agrees, Your Honor.
Let him.
Ladies and gentlemen, the jury, the witness will be accepted as an expert witness
No more
in
questions.
the area of DNA analysis and serology. You may proceed.
Thank you, sir. Now, Ms. Subert, how were you initially involved in this case?
When I was working as a forensic DNA examiner in the DNA analysis unit, I was the individual assigned to this case when it was received at the FBI laboratory.
Okay. And did you issue a report on October 8th, 2008?
Yes, I did. And at this time, if it would be acceptable that I may refer to the notes that I brought with me today that I used in conducting my analyses.
You may.
Guys, could you imagine getting a call that you're going to be asked?
I have the October 8th, 2008 report in front of me.
A witness
Now, I'd like to take you section by section if we can do that.
for the defense of Casey Anthony. Do you realize how long those people probably looked at those subpoenas and was like, God, strike me down where I stand right now? Because people just assume that everyone's like kosher with it. Well, of course, the expert witnesses, they're like, cha-ching, cha-ching, cha-ching. But like the other people who get subpoenaed, who have to come clarify something for the defense and absolutely believe that she did it. Like, yeah, that must be fun at Thanksgiving and Christmas.
To the relevant sections.
Also the hair. Yeah, the hair.
Can you first tell the ladies and gentlemen of the jury what Q's and K's mean.
Sure. At the FBI laboratory, there is a process of assigning a Q letter or a K letter to items of evidence when they're submitted to the laboratory. And this helps to distinguish the location or where the item was collected from. So a Q specimen would be a specimen that was collected from a crime scene. It is something that's not known to a person. A known or a K sample would be a known blood sample, a known hair sample, and things that can be associated directly to an individual.
So if you took my DNA with a buccal swab, I would be K1 or K2 or K3, however number of items.
That's correct.
Okay. And if you collected an item off of the floor, that would be Q1, Q2, and so on.
Well, that would depend.
Okay.
Okay. If you were taking a known fiber sample from this floor, that would be considered a known representative sample, and that would be a K. But let's say hypothetically, if you had dropped a mask or a hat, and that was collected off of this floor, that would be a Q specimen.
Okay. Thanks for clearing that up. Now, were you given items having to deal with the car of a Pontiac Sunfire that belonged to Miss Casey Anthony?
Yes, sir.
Okay. What were you given exactly? And we'll start with, if we can, the first items on your report.
The items of evidence that were received at the laboratory were received into the lab under a cover of communication dated July 28, 2008. And simply a cover of communication just refers to an incoming letter which describes the facts of the case to the laboratory for processing.
You know, I do have an objection that I might raise to the record to whether the items are in evidence, but perhaps counsel can clarify where we're going with this.
I'm questioning the witness work she's done on this case.
Right, but to testify about matters that are not in evidence, obviously that's a predicate, and I thought if counsel could clarify for us, maybe we wouldn't have a problem with it.
Sir.
Okay.
These are items that are in evidence.
If I could get that.
Well, let's approach the side, folks. Okay, ladies and gentlemen of the jury, there are going to be some matters we're going to need to take up outside of your presence. We're going to recess to 10 minutes past the hour of 10.
Yes,
I'm going to ask you not to discuss this case among yourselves. This would probably be a good time to take a special break.
Mr. Baez.
Any additional instructions on behalf of the state or the defense? No, sir. Okay, we'll be in recess. State recognized persons of jury.
Yes, sir.
Defense,
Yes, sir, we do.
you may
It
continue.
shows up
Thank you.
on my screen.
Ms. Hubert, we left off talking about some items that you were given to
Overly
test,
aggressive.
and I'd like to take you through those items. First, I'll refer to Q from your report, Q 13 and 14, which has been identified as State's Exhibit IJ.
This is me.
Can you look at that item, or can you look at your notes and see? Tell the ladies and gentlemen of the jury what you did.
Yes. The two items, Q13 and Q14, and I apologize, I didn't hear the state's exhibit number, IJ, were identified as swabs from spare tire cover collected from the vehicle, tag number G63XV.
You know, if I may, I'm sorry. I think that those probably need to be formally moved into evidence by the defense, which I have no objection before the witness testifies about the analysis.
Okay. There being no objections lodged by the state of Florida. Huh? No, these are me. You wanted, it was marked for ID by whom?
By the
How were the
state, but
cheeseburgers
we'll
today?
move it into evidence. That's fine.
Jury members.
Right, be defensive, they're moving it.
Yes, sir.
Yeah.
Thank you, sir.
Did you have fun
Okay.
during Game 7 of
when you have
the Tampa Lightning?
Defense Exhibit
game?
13,
Your
when you have
members.
that, what's the first thing you did with those items?
So each of those items were looked at independently. So the first item, the Q13 swab from the spare tire cover, was examined in the laboratory, and a chemical test was actually performed on a portion of that swab.
Let me stop you there if I can. Okay.
Please.
When you inspected, you're in a laboratory, correct?
It is performed in a laboratory setting, performed by a biologist of the DNA analysis unit.
Okay. And what is the first thing done? The test that you're referring to, the phenolphthalein test, correct?
Correct. It's a chemical test, which is a test that will detect the possible presence of blood. And it is the official name is called by is the phenolphthalein test. Correct.
Okay. And what were the results of that test?
On each of those swabs, the test for the presence of blood was negative.
Now, I'd like to take you and direct your attention to the second page of your report. on item Q22, which has been entered into evidence as states 143.
On those items, Q23, which was identified as a piece of spare tire cover, a chemical test was also performed on that item for the presence of blood, and it was negative.
Okay. And then after that, with that item, what did you do?
After that item, the testing was conducted on that item. It would have been repackaged up, and then the next item would have been opened up and also tested as well, and that item would have been Q23.
And that is, for the record, states evidence 139. And what did you do with that item?
And that item was identified as a spare tire cover, and on that particular item, there were brown and yellowish stains that were observed, and those stains would have been tested using a cotton tip swab from the laboratory. So distilled water was placed on that swab, and those areas were actually then individually swabbed, and then the chemical test was performed on each of those swabs from each of those stains that were observed, and those were all negative for the presence of blood.
Okay. Now, when we are talking about spare tire cover, that's a round circle cardboard type carpet material?
Correct. A particle board type backing, correct.
Okay. And then can you tell the ladies and gentlemen of the jury what the next item is?
The next item that was examined was Q24, and that was identified as the left side of trunk liner. It was,
just for the record, that's states evidence 139. First, describe the item to the ladies and gentlemen of the jury so they kind of have an idea of what you're talking about.
States Exhibit 139, or my item number Q24, was a dark gray carpeted section with a multi-colored fabric backing on it. And then on that item, again, brown and yellow areas were looked at throughout, and those areas were swabbed and tested for the presence of blood, and they were negative.
Okay. And then what's the next item?
Q25.
And what is that described in your report as?
Q25 is the right side of the trunk liner.
Picking up on it.
Okay. And that, for the record, is states evidence 140.
Wrong charge.
Tell the ladies and gentlemen of the jury what you did there.
On that item, it was another section of a dark gray carpeted section with the multicolored backing, and brown and yellow areas were identified throughout as possible stains. And a cotton tip swab was taken, water was applied, and those brown and yellow stains throughout were swabbed, and then the chemical test was performed on it for detecting whether or not blood was there. And all of those stains were negative for the presence of blood.
Okay. So you had the spare tire well, correct?
Yes, sir.
The left side of the trunk liner and the right side of the trunk liner.
Yes, sir.
And you tested all of those areas for blood.
Objection, asked and answered.
Overruled.
Yeah,
Yes, sir.
no
All of those
shit,
all
Sherlock.
of those items were tested and negative and were negative.
Okay. What did you do with the swabs that you took from those items after you tested the area for blood?
After a swab is taken and the chemical test is performed on that swab is not retained by the laboratory. The chemical test has been performed. The period to see if a color change is going to take place or not has been observed, and that swab is not retained.
Okay. Did you do any other tests on those items?
Yes, sir.
Okay. Can you tell the ladies and gentlemen of the jury what kind of tests you did after that?
Yes, on those particular items, again, I'm referring to my notes.
Sure.
On specimen Q22, which was the piece of the spare tire cover, Q23, the spare tire cover, Q24, the left side of the trunk liner, Q25, the right side of the trunk liner. A swab was taken of those items and processed for DNA typing.
I just want to know why. It's
And what
called
were the results of the
pieces
DNA
now.
typing for the trunk of the car items
Like what?
that you described?
There was no DNA profile generated from those items.
Okay. Now, just so the ladies and gentlemen of the jury can understand a little more about what you do, the phenolphthalein test the chemical test that you did, that was for blood,
Sorry,
correct?
Excuse me.
That's correct.
Is it fair to say that the reason you took it a step further was because there are more types of bodily fluids that you could pick up with DNA that you can't from that chemical test?
Objection, leading.
Sustain, rephrase the question.
Why did you do the DNA test?
Well, although the chemical test for the presence of blood was negative, the next step was to determine were there any other type of biological cellular material that could be detected through swabbing and a DNA result generated from that. So from any cellular material that could be present, or if there were any other types of stains that were there that weren't necessarily observed that could have contained DNA material.
And what can you get DNA from in a person's body?
Well, DNA is contained within every cell of your body except your red blood cells. They don't contain a nucleus. So any type of cell that has a nucleus is where the DNA is housed. So skin cells, white blood cells, the tissue, if you yank out a piece of hair, the tissue that's contained in there, and all of those cells within the nucleus contain the DNA, and that DNA is the same in all of your cells.
Okay. All right. Now, further down on page 2 of your report, you received. Can you describe to the ladies and gentlemen of the jury what the items are from Q33 to Q43, and just for the court, the state and the defense have a stipulation with no objection on the description of these items.
If Counsel could just remind me which item those are, the clothing. So, no objection.
Okay.
I believe the agreement is that those are the items referred to by Investigator Boise as being clothing from the Anthony home.
Thank you, gentlemen.
Thank you. You received some items from closet of East Room at 4937 Hope Spring Drive, correct?
That's correct.
Okay. Can you tell the ladies and gentlemen of the jury what you did with Q33 and so on?
Yes, so the items that were submitted from the closet, there were several different particular items, and I'll start with the first one, which was Q33, which was identified as a pair of pants. They were dark gray color, and that item was visually examined for the presence of any biological stains, and none were observed. So in that case, on that particular item, there was no chemical testing performed.
Okay, and what about Q34?
Q34 was identified also as a pair of pants, and they were actually light blue pants in color. And that item had some faint brown, yellowish brown spots contained on those pants, which were tested for the presence of blood and tested negative for the presence of blood.
Okay. And Q35?
Q35 was identified as a pair of pants. They were a pair of blue jeans, and a visual examination was performed on that item, and no biological stains were observed, and therefore no chemical testing was performed on that item.
Okay. Q36?
Q36 was identified as a skirt. It was a light gray skirt and had some very faint yellow type stains contained on that skirt, which were tested for the presence of blood and tested negative.
And Q37?
Q37 was identified as a skirt, and it was a light yellow skirt, and there were faint red spots throughout, primarily on the outside, the front left, and those were negative for the presence of blood.
And Q38?
Q38 was identified as a skirt. It was a light beige skirt and had faint yellow areas contained on it, and those areas were tested and were negative for the presence of blood.
Q40? I'm sorry, did I skip 39?
Correct. There's Q39. Q39 was identified as a shirt. It was a light blue button-down long sleeve collared shirt, and it had some faint discolorations contained on the left breast pocket, and those areas were tested and were negative for the presence of blood.
And Q40?
Q40 was identified as a shirt. It was a light beige button-down 3/4 sleeve collared shirt, and there were some faint areas of discoloration on the outside front lower right, which were tested for the presence of blood and were negative.
Q41?
Q41 was identified as a shirt. It was a bright pink sleeveless turtleneck shirt, and that area was visually examined for any biological stains. There were none observed, so chemical testing was not performed on that item.
Q42?
Q42 was identified as a shirt. It was a light pink button-down 3/4 sleeve collared shirt. A visual examination was performed on that item, and there were no stains observed, and therefore no chemical testing was performed.
Okay, and Q43?
Q43 was identified as a shirt. It was a green button-down 3/4 sleeve collar shirt, and a visual examination was performed on it. There were no biological stains observed, and therefore no chemical testing was performed on that item for blood.
Was there any blood on any of the clothing that you received from the Anthony home?
No, sir, not on those items.
Did you receive any other clothing that's not in this report that you tested?
From the home?
Yes.
No, sir.
Okay, I'd now like to take you to...
At what point, I'm asking this honestly, and whatever, I mean, everyone's entitled to an opinion, right? So just keep that in mind. My opinion happens to be that, well, I have a lot of opinions, but I want to know when you guys think that the state, when and if the state started listening to Jose's defense like strategy and was like, oh shit. Like that's valid. That's reasonable doubt. Like for those of you who watched it before, I know K-Dubs watched it before. I hope that you remember that part because I'm very interested on paying peak attention to that.
The next item, Q44, which is State's Evidence 323. Can you tell the ladies and gentlemen of the jury what that is?
Yes, sir. Q44 was a piece of the spare tire cover, and it was a gray carpet cutting. And Q45 was a piece of spare tire cover as well, and it was also a gray carpet cutting.
Okay. And Q44, what did you do with that item?
That item had some extremely faint brown dingy areas on it that were spot tested for the presence of blood, and they were negative for the presence of blood.
Did you do anything beyond that?
On that particular item, it was actually combined with the next item for DNA testing.
Okay. Let's go to Q45, which is State's Evidence 142.
On Q45, there were extremely faint brown dingy areas on that item that were spot tested, were tested for the presence of blood, and they tested negative as well.
Now, tell the ladies and gentlemen of the jury what you did with both of these items together after you tested them for blood.
On those two items, a swabbing was taken, just a regular cotton tip swab with water applied to it, and a swabbing was taken of the entire item, as well as the Q45 item, and those two swabs were combined and processed for DNA.
Okay. And can you tell the ladies and gentlemen of the jury what the results were?
There were no DNA typing results obtained from either of those items, and they were combined, so there was essentially no DNA as a result.
Okay. I'd now like to direct your attention to the report that you issued on October 9th, 2008. Just let me know when you have it.
Mr. Baez, let it take your time. Sir, don't be so rude.
I have that report in front of me.
Okay. Ms. Subert, can you tell the ladies and gentlemen of the jury what item we're discussing and a description of it and the Q number?
From the October 9, 2008 report, the items of evidence that were examined were Q46, which was identified as a shovel, and Q46.1, which was a label from the Q46 shovel blade.
Okay. And for the record and court stipulation that we could describe these items without any objection.
That these are the items testified to by Brian Berner, the shovel testified to by Mr. Berner earlier in the case. We do agree. Thank you.
Okay. And could you tell the ladies and gentlemen of the jury what you did with the shovel?
Yes, the shovel was examined for the presence of blood. And so visual examination was performed on that to identify if there were any possible stains. There were some areas that were in fact tested on the shovel, and those areas were negative for the presence of blood.
Appreciate it, Nikki. That was so nice of you. And this is the Casey Anthony trial from 2011.
Now, I'd like to direct your attention to your report of December 16th, 2008. I know you issued two, but I'll let you know which one specifically.
Before we leave this report, I wanted just to be sure the testing that we discussed was the specific to the serology, but there was also DNA performed on that. So I just wanted to be clear on that.
Okay. And what were the results of the DNA?
There, a DNA profile was not generated. There was a sex typing result at the amylogenin locus or the location, but it did not satisfy the reporting criteria of my laboratory.
Okay. And just so we can explain that a little bit.
Of her laboratory.
When someone grabs and touches an item, DNA is left, correct?
It's possible.
Okay. But would the touching of the how much DNA you recover depend on the item, how much force is used, and other factors? Can you tell the jury a little bit about that?
Objection, leading and compound question.
You
Sustained
aren't
rephrase
alone,
question.
though.
Can you describe to the ladies and gentlemen of the jury a little bit about touch DNA?
Well, touch DNA refers to,
Let me object to the relevance since
Oh my
there was no,
God. Are
she
you
indicated there
for
was
real,
no-
Mr. George?
I found that the relevance
Come on.
is explanation.
I think it goes to
well, touch DNA refers to a type of DNA testing where you expect to have very limited amounts of DNA left behind. It's on items that I've had contact with an individual, such as perhaps a piece of paper. If you pick up a piece of paper and you hold that piece of paper in your hand for a little bit of time, it's possible that you've deposited some type of cellular material from your hand on that piece of paper. But in order to get a DNA result that is typable or usable depends on lots of factors, how long you perhaps had that in contact, and if you are capable of leaving a lot of skin cells behind. And so that all comes into play when you're looking at a DNA result when we're talking about samples that have had limited contact.
Now, when we talk about levels of DNA, how is that measured?
Not sure I understand your question.
What are RFUs?
RFUs talk about relative fluorescent units.
To the relevance to the approach.
You may.
Maybe that was right.
Yeah, objection overruled. You may continue.
Okay, Mr. Rick, you've already described to the ladies and gentlemen of the jury what touch DNA is, right?
Yes.
What is low copy number DNA?
I have some bad puppies I'm dealing with.
Members of the jury, can you give Mr. Baines?
Yes.
Thank you.
Actually, if I can help. Sure. Thank you.
My husband's like, oh my God, look how bad they are. And I'm like, oh my
Okay.
God, this is what
Can
I
you hear me?
do
Can
every
everyone hear
day.
me much better? All right. Ms. Siebert, I'm sorry. Can you explain low copy number DNA?
So low copy number DNA is a type of DNA process where going into performing the DNA testing on it, the individual knows there's going to be a limited amount of DNA information there. And so there is a procedure
This
that can be
was-
performed to
Yesterday or else the day before. I think it was the day before. Yes. The coroner who had a lot of problems with a lot of things and kind of yelled at the defense attorney. They tested the baby's femur for like the actual bone for chemicals, and there's no way to show up negative and not have like, you can't fake that test. You know what I'm saying? Unlike a serum test. And that's been a common thought to a lot of people. I'm struggling speaking today. I wonder why. It might have been like the 5 Jell-O shots last night. So I'm just going to keep going.
enhance the DNA analysis process to make even more copies, which we haven't really talked about in the PCR process. So it's actually adding on some of the molecular xeroxing during the polymerase chain reaction when you're actually making multiple copies of DNA to enhance the end result, the DNA profile. So going in, you know you're going to have a limited amount of DNA. And so you're actually enhancing your DNA analysis process to adjust for that, to make more copies to generate a result. And with that result, you have to, there's certain evaluations that have to go into those results because of the nature of low copy number. Since you don't have a tremendous amount of cellular material at the beginning, there are some things that in the end that have to be evaluated in order to generate the reliable result.
Red on my nail.
To have a reliable result.
Okay, so when we say low copy number DNA, I know these two terms are used interchangeably at times, but that's incorrect, right?
That's incorrect.
Okay.
Right. Touch DNA can be samples where at our laboratory, if a firearm comes in and you think about the nature of when you hold a firearm and you put your finger on the trigger, your hand on the grip, you're coming into contact with it, but not necessarily for maybe an extended period of time. So that would be an area that we would swab, knowing that that's where an individual's had contact. I would expect perhaps to get a result for the deposit of skin cells, but I'm not going to enhance my technique to make more of those copies from my normal analysis procedures. I already expect to have limited amounts, but at the current, when I was in the unit, we didn't have procedures to perform low copy number, which is enhancing the analysis techniques.
Now,
Happy
I want to skip
Chinese
ahead
New
a
Year,
little bit to
everyone.
when you actually get the readouts
Celebrates.
of the DNA results. Can you touch briefly on that? Because I don't want to get too technical.
What the end readout or the profile is.
Correct.
Okay. Can I back up even a little bit more just to talk about the DNA process?
Sure.
Okay. since we haven't talked about it, the actual DNA process, how that occurs is, let's talk about a swab. We've talked about doing a swabbing of the carpet, out of the trunk, the spare tire cover. So that swab is put into a tube, and there are chemicals that are added because in order to do DNA typing, we have to get to the nucleus of the cell where all the DNA is housed. So those cells have to be broken open in order to really get to that DNA and unwrap it from where it's contained within the nucleus. And so we're able to do that by adding chemicals. And then that DNA is now taken through the process. And the next step after we're able to extract that DNA away from the item that it's contained on is what's called the polymerase chain reaction, the PCR. And what that is essentially a molecular Xeroxing. It's like going to a copy machine and making billions of copies of that one page that you have, that you need copies of, but we're actually doing that at multiple locations on the DNA. We're actually looking at 13 locations on your DNA. And so we're taking all of those 13 locations and making multiple copies of the DNA that's present. And so the next step then is to actually, utilizing an instrument, the DNA is put into a capillary column through a process called capillary electrophoresis. And this instrument has a very small capillary column where the DNA in that liquid form is injected into this capillary column, and we're able to detect it through a process using a laser. And we talked about those RFUs, or those relative fluorescent units. What that's telling me is it's signaling that there's DNA present. And it's able to send that signal to a computer, which is collecting all of that information, and then it's interpreted into a DNA profile. Much like if you've been to the doctor and you have a heart monitor set up and you get an EKG done, you see those peaks on the EKG machine. That's what essentially my end product looks like, those peaks. And those are representative of the DNA profile from that initial test tube where we extracted the DNA out, and we were able to remove it from the inside the nucleus of the cell. And now I'm able to see the end result and generated a DNA profile, which I now will use in my interpretation.
Okay. And what you get through your readout, which are called electropherograms, correct?
That's correct.
Okay. And what you get are some squiggly lines and some peaks, do you not? Among other things.
Yes, the peaks are what I'm most interested in.
Right. Okay. And what you talked about to the ladies and gentlemen of the jury are the 13 different locations of where you search for DNA, correct?
Correct. The 13 locations, yes.
And these are also identified as markers.
Correct.
Okay. Points of interest, so to speak.
Correct.
Okay. And depending on how much DNA there is there, well, the peaks also indicate to you how much DNA is present at that specific marker, correct?
Correct. The RFU units will be higher depending upon the amount of signal that's being sent to tell the instrument that it's detecting the DNA that's passing by that laser and creating a fluorescence, which is being collected and is outputted into a peak.
My bad.
Okay. So if you have, what are the cutoff levels for your laboratory when reporting out something as DNA being at that specific location?
To actually report a
Did you
DNA
make a
type,
nuclei?
the threshold for my laboratory at the time I was in the unit was at 200 RFUs. And that was our match interpretation threshold. So anything above 200, I could use to make a match with.
Okay. And there are other
He's
laboratories
struggling.
and other
He's struggling.
kits
He's like-
that can actually report lower levels, correct? That's just that 200 for you to report.
Exactly.
She can ask the question.
For you,
What the
that,
fuck?
that 200 level number
starter?
is a determination made by your laboratory.
Right. That number was based on the validation by the FBI laboratory at the time when we were validating the instrument and the kit to do the DNA typing in the unit.
But it is common in other laboratories that sometimes the threshold can be lower. Is that correct?
Other laboratories will have different interpretation thresholds. That is correct.
Okay. And can you explain to the ladies and gentlemen of the jury as to what your threshold is to exclude an individual?
Any information that falls below that 200 RFU interpretation threshold can be used for exclusionary purposes. But there is one more threshold that's not depicted on your chart.
Okay. And what is that?
That is at 50 RFUs.
Okay. And what does your threshold with 50 RFUs mean?
50 RFUs is the threshold
protecting
for where
my
a peak
masterpiece.
will be labeled a peak. That is our peak amplitude threshold, which is based upon the validation of where a peak will begin to be detected in the FBI laboratory.
Okay. Basically, some people will call these other items down here noise or artifacts.
There are other laboratories that may in fact use the threshold below that 50.
Okay. And
Dead.
if in your laboratory, if you see something that's 50, you can call it a peak.
That's correct. That is when the threshold for identify or labeling a
agree
peak
with this.
begins.
And would you
can
consider
do
the
no harm,
laboratory thresholds that the FBI uses as conservative?
The 200 RFU threshold it's a relatively
She even
conservative
spelled
threshold.
that
Yes.
wrong, and,
And the 50?
she's right. Like, she's a queen.
Conservative.
Proud of her.
Well, it's based on the validation, so I would say that is a scientific threshold based upon the validation for when reliable results are generated.
Hey, what's up, guys? I see we got a lot of new viewers. If you could do me a solid and please smash that like button for this stream. And if you haven't already subscribed to my channel, why? It's free. And the more you comment, the more likely you are to get a gifted membership. Lots of cool stuff. Please do it. Thanks. Bye.
Okay, now you told the ladies and gentlemen of the jury about you being able to call something at the level of 50 a peak, correct?
Correct.
Now, and that would give you an indication that there's something there.
Are you sure
Correct.
it starts
At 50?
next month?
Yes, at 50.
Correct.
But unless it reaches 200, you can't report it out.
If it is at the STR loci, cannot be used
Hell
for
yeah.
inclusion
You
unless
are
it is
the
above
person.
200.
Thank
There's an
you.
exception with
Thank you
the amylogenin or the sex typing locus where information can be used
Ben
if it's below
Hammer.
200.
And to kind of bring it all together with what we talked about with the shovel and some other items that we're going to talk about. When you say that you cannot report it, it doesn't mean that there isn't some DNA there. It's just something that your protocols preclude you from making or giving an opinion on, correct?
Objection. Competition to counsel.
I'm sorry.
Okay, you
What?
can approach.
No, I think based on the court's earlier ruling. Real quick.
Yeah.
The one time
Okay,
I
members
get
of the
off my
jury, there's going to be a
screen-
brief legal matter we need to take up outside of your presence. I'm going to ask that you step outside. We will get back with you as quickly as possible.
Oh, damn it. Maybe I wish maybe could do things like type things on the screen for me.
Okay, the jury is outside of the presence of the courtroom. You may proceed with the
You
proffer.
know what I mean?
Ms. Uber, the amylogenin peak that was derived from the shovel, can you give us the RFU for that?
Certainly.
Did you heed my previous day's admonitions? All right. Please bring the jury. Whoops.
On the swabbing from the shovel at the amylogenin locus, there was an X for the female that appeared at 55 RFUs.
Thank you. I think that answers our question, Your Honor.
Oh, okay.
Yes.
The import of that then would be to
exclude it as being from a man, but not identify it as a woman. Is that how that would be interpreted?
Well, it's at such a limited amount, I wouldn't be able to give any type of information pertaining to that.
Oh, so you can't draw any
I
conclusion?
cannot draw any conclusions from that limited information.
Judge, that would be my objection. It's a result from which scientifically no reliable conclusion can be drawn. Therefore, it would not be admissible. To tell the jury this and to ask them to somehow interpret it in some way different than the witness does would, I think, be improper.
If I may briefly respond, Judge, I'm not asking her to report the results or to identify that it came from a female. I believe the witness has already testified that if it reaches the 50 threshold, that is an indication that there's something there, that it is beyond a artifact. That is all that I am attempting to elicit from the witness. Nothing more, nothing less.
Question, what's the relevance of that? What difference does it make if there is something there that cannot be scientifically interpreted to mean anything? Then what is the relevance of it?
The relevance is that there is DNA there, not sufficient enough for her to make a determination as to who it belongs to or what it is, but there is something there. And that is it, nothing more. Now, there's a huge difference between being able to report something, exclusion or inclusion. We're not discussing that. We're discussing whether DNA material, and the witness has already testified that if it passes the 50 threshold, that is an indication that there's something there. That's it. As far as now, if that is fair game for cross-examination when Mr. Ashton wants to get up and say, you can't say this, you can't say that, you can't do this. And that's fine. But as far as what I'm trying to elicit from the witness is simply that there was a portion of DNA there. And that's it, nothing more.
Table here.
The problem is, to what end? Is counsel going to elicit this and then at some later point argue to the jury that somehow that bit of DNA could have been amplified, could have been this, could have been that, without scientific support? Unless it is relevant to an issue, then It's meaningless. It's not relevant.
If it's not relevant, why is the shovel in evidence?
Judge, the shovel is an evidence.
Mr.
Counsel
Ashton,
knows why the shovel-
Mr. Ashton, calm down.
Sir.
Okay, calm down. Sit down for a second.
Oh,
Okay, have you finished, Mr. Baez?
My point is, Judge, this evidence has been,
I
this
love
shovel
it.
has been brought into evidence. It is a relevant piece of evidence. There's testimony been admitted that Miss Anthony borrowed the shovel.
I'm not concerned. I'm concerned about her testimony and what she's going to say. Okay, you have anything else to say about her testimony?
Nothing further, sir.
Mr. Ashton, reply from the state of Florida.
Yes, sir. I still would submit that the fact that there is a scientifically meaningless result on a test isn't relevant unless it can be tied into some issue in the case. And my concern is that counsel is going to, without eliciting from a witness whether this could ever be used to do anything, argue to the jury something that we know is scientifically incorrect. I think it needs to be
I need
relevant
to clip that.
for some argument or some issue before the court.
The comments to that, Mr. Ashton, is those are things that you can ask her in your cross-examination. Ma'am, the results that Mr. Baez is seeking to elicit from you,
Why is it so close now? Why? I
exactly what does those results mean?
need a new tripod. There's always
All I
just
can tell you, Your Honor, is that there is a peak there,
Yeah.
and it is,
Please
Is it
donate.
DNA?
considering that the initial threshold of determining a peak
Rift,
is
man.
at 50, and that peak does appear above 50 RFUs, it is a peak and is consistent with an X of at the amylogenin typing or at the locus. So I have no other information other than there is a peak.
There's a peak and it is an X. you
There's a
say?
peak,
Yes, sir.
And
everybody.
what does that translate into?
Well, it's potentially could be from a female, it could be from a male. It's at such a low level in my report for the conclusion that I gave is that it is do not satisfy the reporting criteria, and no conclusion can be offered.
So you can't say whether it originated from a male or a female.
Well, with the absence of a Y peak, all I can tell you is there's an X there.
And you can draw absolutely no conclusions from that.
No, sir.
Okay.
That's problematic,
Or any
ma'am.
conclusions of the witness, nor will I ascertain. The only thing that I was
Okay,
attempting
let me cut both of you short. Okay. I will permit you to ask the question. The state can clear it up in cross-examination, and then the jury can take it for whatever it's worth. Okay?
Yes, sir.
Anything
Oh
else,
my
folks?
God.
Your Honor, may I ask a question?
Yes, ma'am.
And I don't know how the information will be presented, but it is at a level that, since it's not in my report, I would have to be speaking about the result from a table that's in my report if we're going to address that.
Got
That's
the
in my
shape.
case file to address that
Huh.
specific piece of information.
Okay. Anything
really
else,
don't.
folks?
Nothing further.
Okay, let's return to jury.
I'm actually not hungover, but I am digging this vibe.
Okay, state recognized presence of jury. Defense?
Yes, sir, we do.
Okay, Mr. Baez, you may proceed.
Thank you. 1, 2.
I need a
Can everyone
monitor.
hear me? Okay. Ms. Subert, where we left off, and I'm just going to recap for a moment before I ask you my next question, is we talked about the different thresholds of how much DNA is present on your electropherograms, the readouts. And when we were talking about the shovel, you mentioned that at one of the markers, there was something that reached above the 50 RFU levels. Is that not correct?
Correct.
Okay. It did not reach the 200 level, and you did not have multiple markers or sufficient markers to be able to report it out, correct?
That's correct.
So is a fair statement that there is something there, you just can't report what with any degree of scientific certainty?
Sustained, rephrase the question.
What's the best way to summarize what's there and what's not there?
I wanted to show you guys something.
Well, at the locations that the short tandem repeats would be present at, the 13 locations, the DNA profile, a result was not obtained at any of those 13 locations. For the amylogenin or the sex typing locus, which would indicate male, female DNA, there is a indication present of DNA at that location, but it does not meet my reporting criteria.
Perfect. Okay. Now I'd like to direct your attention to the next report that you issued in this case on March 19th, 2008. I'm sorry, that would be 2009.
Wait, is this even going to show up as a link? Nope, never mind. It's not going to show up as a link. Let me delete it.
And let me know when you take your time. Just let me know. I know you got a lot of stuff there.
Copy link. Maybe if I copy it this way, it'll work.
You may.
Oh, it worked this way.
I have that report in front of me, the March 19th.
Hold on for
Sorry.
the court.
You may proceed.
Have you had sufficient time to get your documents?
Yes, sorry about that.
And you have your March 19th, 2009 report.
Yes, sir.
Okay. Can you explain to the ladies and gentlemen of the jury what these items of evidence were?
So items that were reported out on the March 19th, 2009 report were identified as Q62 through Q64 as tape, which were items from the medical examiner's office.
And for the record, this is state's evidence 302.
Thanks
And
for
are we talking about duct tape?
Yes, sir.
Okay. And these were
Happy New Year.
duct tape items that you received from the medical examiner's office?
Yes, they were submitted to the FBI laboratory, and the origination of where they were collected from was identified from the medical examiner's office.
Okay. Can you explain to the ladies and gentlemen of the jury what you did?
On the items of the tape, they were examined, and there were three pieces, Q62, Q63, and Q64. And that the first examination was done on the top side of the tape. I'll refer to it as the silver side of the tape. And a cotton tip swab was taken, moistened with water, and the top side of that silver area was swabbed to collect any possible biological material that would be present on that silver side of the tape.
Okay. And when you say the top side, you're talking about the non-adhesive side?
That's correct, the top side, yes.
Okay. And were there any distinct markings on the top side of the tape to help you identify the item of evidence?
I have a description here that the manufacturer's logo, Henkel, spelled Henkel, was throughout the tape.
Okay. And did you get any results, any DNA results from the top side of the tape?
Yeah, so the swab itself DNA typing was performed on that swab that was collected from those three areas of tape, and a DNA profile was generated. However, it was below the interpretational threshold of the FBI laboratory's reporting policy.
Okay. And when you say below the threshold reporting policy, can you give us how many markers were present, number one?
On the top side of the duct tape, or the silver side of the duct tape, an STR result, or the DNA typing result, was obtained at 6 of the out of the 9 locations that were tested. And if I can just back up and describe that
Sure, please do.
for you. So in doing DNA typing, there's actually 2 typing kits. They're called amplification kits that are utilized to come up with the totality of the 13 locations.
Let me ask you, I'm sorry, Ms. Subert, would it assist you to write would it assist you to use the board to kind of explain it a little clearer, or do you feel comfortable enough doing it from stand?
As long if it becomes confusing, you can let me know.
I don't know if the jurors can let you go. Your Honor, may the jurors raise their hand if they're getting a little confused on the issue?
No.
I can list out the locations if that would be helpful.
That might be a little helpful. May the witness stand down, Your Honor?
Yes.
Okay. I can hold your papers if you want. Okay, sure.
Okay. So the areas that we've kind of talked about, there are 13 locations on the DNA, and they are selected because of they're highly polymorphic, or they're very different between individuals. And they're actually located on different chromosomes. And we haven't talked about chromosomes, but you actually have 46. 23 of them came from your mother, 23 of them came from your father. And so on those chromosomes, certain locations have been identified as being highly polymorphic or different, that have been selected to be looked at in forensic DNA typing. And so within one of the kits, there are actually 9 of those locations that have been identified, in that we will amplify the DNA with, or target those locations, make the copies, and generate, if there's enough DNA there, a DNA result. And so I'm going to write out those DNA locations for you so you can see their names, and I can tell you a little bit about what each of those names means.
That helps me so much. You let me know which part of the stream to clip.
I cannot see that. You just push back. Yeah, that's fine. Right where you had it was fine. I can't see it.
Can everyone see it? Okay.
So what I've listed out here are each of, well, this is 9 of the locations that we would look at in one of the tests or that are contained with one of the kits. And that kit that I've listed here is the Profiler Plus ID kit. And each of these locations, this one is D3S1358. D3 is actually on chromosome number 3, and it is the location. It's basically like house address on the chromosome. If you think of the street that you live on, it's the main street, and it's kind of like the house number for the area that's been targeted. And so as you go down the line, you have BWA, FGA, D8S1179, D21, I'll shorten them, D18, D5, D13, D7, and then amylogenin, which we've been talking about as the sex typing locus, which will tell whether or not you have male or female DNA present. And so what happens during the DNA typing at the very end, as a part of my analysis, when I do my interpretation, I'm actually looking at the peaks that Mr. Bias talked about earlier at each of these locations. So at D3, I would actually look at if there are peaks present and what the DNA type is for each of those peaks, and then I would populate the table, which would represent the DNA profile. And what these peaks actually represent, and we talked about is DNA, but these are actually the short tandem repeats. They're STRs, which are the types of DNA repeats that are present at each of these locations. And so essentially counting up how many of those repeats are present at each of the locations that were examined.
And do you get one of those numbers from your mother and one from your father?
That's correct.
Okay. And what happens if both of your parents have the same one at that location?
So if your parents have the same STR type at that location, then you're going to have just the one peak. So for example, let's say we'll call this D3 here. And let's say this is a 15, 16. And let's say we go to VWA and there's just one peak there. That means both your mother and father had given you that one type, and then you would just be, we'll call it a 10. And so both parents have given you that 10 as part of your DNA makeup at that location.
So what we've looked at so far that you've written, in a hypothetical situation, this person would be a 15, 16 at this marker, and then a 10 at this marker.
Sure, and that's, yeah. So each of these markers, there will be if there's enough DNA present to generate a result, there will be a peak or 2 peaks present if you have a single source sample.
And when you have the full combination of the 13, that is when you have a DNA profile.
Well, you can actually have a DNA profile just at one location. So you don't necessarily need all 13 to have a DNA result. It could just be at one locus, it could be at 2, it could be at a combination of them. And so I've only listed out 9 of the locations here. The second test actually has another series of these locations contained within it that are targeted. And that's where you get the additional loci would be in the next test or locations.
And depending on the marker, it tells you how discriminatory it is, meaning how many people might have that number at that location?
That's actually a different part of the process.
I mean, and that's, I know we're kind of jumping ahead, but as it relates to the duct tape, what did you find on the non-sticky side of the tape?
In my report, I identified that there was an STR typing result obtained, but it fell below my reporting threshold. So if I list that profile here,
this is important.
If I can list it as such that it would be representative of a profile that I would that would fall below my reporting threshold. Okay. If I can write it out that way, but indicate that.
Okay, that's fine. That's fine. We understand.
Okay.
We understand.
Now, how many of these markers do you need to exclude someone?
It could just take one marker to exclude an individual.
Okay. In what you obtained, could you exclude Casey Anthony?
Now we're talking specifically to this particular item.
Correct.
Yes.
Okay. So Casey Anthony was excluded from what you got so far.
Yes.
Okay. And was Kaylee Anthony excluded as well?
Yes.
Okay. Did you do something further to try and determine who this partial profile belonged to?
Yes, I did.
Okay. What did you do?
Well, after I had generated this DNA profile, I used all of the known samples that were submitted to the laboratory, the known blood samples that were submitted from Ms. Casey Anthony, the known profile that we used for Kaylee Anthony, as well as other family members that had been submitted, Cindy Anthony, Lee Anthony, George Anthony, and I compared those profiles to this DNA profile that I had generated. And all of those individuals were excluded from this profile.
So.
Okay. Did you take it a step further? Actually, we probably get you back to the witness stand.
Thank you.
Take that from you so I can get it to Steve.
Considering that she is a biologist. with the Federal Bureau of Investigation.
What was the next step that you took to try and determine who this might be?
Based upon the generation of that profile in it, and I had excluded the known samples that had been submitted as a part of this case submission, the next step was to evaluate the staff database that was maintained as of the DNA analysis unit. So the individuals who work in the DNA analysis unit will provide a sample and will maintain a database of all of those types to compare when a profile is generated to determine if it could be one of the staff who would work the case or who are working in the laboratory.
Okay. And did you find someone that matched all of these different markers?
Not, and they're not from the DNA analysis staff database. No, I did not.
Okay. What did you do to, what further did you do?
The next step that I did was I determined what other units at the FBI laboratory had processed this item of evidence. And knowing that the profile I had was a female profile, I started looking at specifically any female female examiners or technicians that would have handled this item. And so working with the evidence control unit, I was able to identify which units this item had been processed in. And I contacted those individuals and asked if they would give a DNA sample.
And did they?
Yes, they all did.
Okay. And who did it turn out to be?
This profile was
I'm not looking at
matched
the chat,
to
so
Lori
give me one
Gottesman,
moment, please.
the question document units examiner.
Okay. Now, this is, well, let me ask you this first.
He's even
Is it
confused.
possible when you contaminate DNA that it may overwrite DNA that's already there?
Well, it would depend on the quantity of the DNA that you're suggesting is the contaminant. So there would be some factors that would have to be considered with that.
Okay. Explain those factors.
Well, depending on the quantity of DNA, if you have a very large quantity of DNA, it is possible that it could shadow or hide the very small presence of DNA from another individual. However, on this specific item, the profile itself is at low levels. And so if there had been an additional individual present, I would have expected to see a mixture at some of those locations.
But that would only include if you had
Okay, I'm back.
various,
Sorry, guys. I had to create
a large
something.
enough amount of DNA to account at different markers, correct? Meaning if you only had 2 markers and this DNA overrode that, or just.
Hey guys. Oh, perfect. Still shot. I see we have a lot of new viewers. What's up? This is Lacey Meeks. This is Criminally Confident. I go by Lacey Jane. Would love if you please like this stream and subscribe to my channel. We cover new and old trials, and it's a friggin' party, man. So thanks for stopping by.
One, it is certainly possible that this would overshadow any DNA.
Objection to assumes hypotheticals not based on facts and evidence.
Sustain, rephrase the question.
Yes. If it's still possible that this contaminant could have contaminated other DNA that's there, correct? At lower levels?
I would have expected at the levels that this profile is at, if there was an additional profile there, I would have expected it would have been mixed with another profile if contained there.
And what if that profile that might be there would be at such a low level that it got overridden with this? Is it still possible?
Objection. Hypothetical not based on facts and evidence.
Yeah, I mean, it
I'm
is
asking her a
hypothetical.
scientific question, Your Honor. She can
okay.
answer it.
That's
Sure,
based upon
whatever.
facts that are not evidence. And I would submit.
He is heated
I don't
today.
think, Your Honor.
Sustain. Yeah.
Okay. Let me
And
ask you
Baez
this:
is a little
Does
shaky.
can contaminating DNA override something that's already there?
Objection. That's an answer.
Overruled. I'll let her answer the question.
This is a hypothetical. If you contaminate an item, can it override DNA that's already there?
If the presence of a very large, you have a very large volume or percentage of DNA deposited on an item in a very small amount of a second individual, it's possible.
Okay. Now, the item of evidence got to the DNA lab much later through the processing of this duct tape, did it not?
We were the last units, yes.
Okay. Is that common?
Not sure how to answer your question if
Hear
it's
that?
common.
Sure. would it have been more advantageous for DNA to get the duct tape first, the DNA lab to get the duct tape first before other technicians had already had access to it and potentially contaminated it?
It wouldn't have altered the way that the tape would have been processed in my unit.
Okay. But it would have reduced the possibility of other people contaminating the duct tape.
Well, anytime an item is handled by fewer people, there's a less of a chance of another or of individuals' types being deposited on that item. So sure, the fewer people that handle an item, the less chance there is of a contaminant or another DNA profile being deposited on it. But that still didn't change the way that I would have processed that item.
No, I understand, ma'am.
Finally.
And from your understanding, how many divisions and people got to this duct tape and processed it before you got it?
Well, the examination plan is developed by the evidence control unit for the movement of items in the laboratory, and that's where the decision is made for the movement of items in a case. And so on this particular item, there were several different types of examinations that were going to be performed. So it went through the trace evidence unit, the chemistry unit,
When
latent
did
print
he say
unit, and the
that?
question document unit
SDG.
prior to the DNA analysis unit receiving it.
Okay. Now,
I have not.
The-
I've seen one public statement from him.
it was your understanding as
Since
well
trial
that
regarding-
the duct tape had been exposed to numerous elements, right?
The case information
Hallelujah.
did describe that the location of where the evidence was collected from was outside and would be
Someone needs
have
to get-
water in it at times. And so, yeah, so it was conveyed in the incoming letter that it was outdoors.
BRB.
Now, the elements do and can degrade DNA, does it not?
Overall,
Sure, the elements, sunlight can destroy or deteriorate the DNA that's present. Humidity, those several different factors of being outside could impact the amount of DNA that would be left on an item.
So why do you then do the tests?
Well, based on the item itself as being evidence in this case, it was my thought that from a forensic standpoint, the item should be swabbed to determine if there was any DNA present on that tape that was left on the victim.
Okay. And you can still get DNA even from items that are underwater, can you not?
So I thought it was objection leading.
question calls for a yes or no answer. Chaz, can you get DNA from an item that's underwater?
I don't believe that was the question. That's right.
I believe it was, Judge.
And you still get DNA even from an item that's underwater?
Yes, so that's what I objected to.
Overruled.
Huh?
Can you answer the question, ma'am?
In a yes or no fashion, Judge?
It calls for a yes or no answer? Unless you need to explain.
If I could have the opportunity to explain.
Go ahead.
Okay, thanks. It's possible, but there again would be several different factors that would be involved in the length of time an item has been submerged, what type of biological fluid, was it blood, is it semen, is it other types of biological fluid that were present on that item. So there are several factors that would be considered into whether or not you would be able to obtain a DNA profile from something that has been submerged underwater.
And in fact, you can also get DNA from profiles from people who've been burnt victims, correct? Can you not?
Sustain.
Do you know if you can get
What?
a DNA profile
Why are we
from
talking
someone
about
who
burnt
has been
people?
burnt or a burnt victim?
Yes, sir, you can.
I'm sorry. Why?
And are there multiple variables that could determine whether a DNA profile can be generated?
Sure, there are variables that the generation of a DNA profile would have to be considered. Sure.
Okay. And is it fair to say that you never know what all the variables are until you actually test it?
Objection leading.
Oh,
Sustain, rephrase your question.
made
sir.
it- he,
Would you
like,
know what all the
romanticized
variables
it.
are of a specific item before you test it?
No, I don't have all the knowledge of an item prior to its coming to the FBI laboratory.
Okay. So is it possible for you to know whether you'll get DNA from an item unless you actually test it?
Can I answer that outside the yes or no, sir? Well, that would depend. If it's a blood sample that is a red-brown stain, I expect to get a DNA profile from that reddish-brown stain that I've concluded is blood. If it is a general swabbing item that I've not identified any biological staining, but I'm trying to collect biological material, in that case, I don't know if I'm going to generate a DNA profile.
Okay. And when dealing with duct tape specifically,
I'm creating a new poll.
Where would you expect to get a profile? Where would you expect to get a better chance of getting a profile? The outer portion for the person applying the tape, or the inner portion where it might be attached to someone's face, saliva, and other bodily fluids might be getting on it?
Objection to a hypothetical outcome in this case.
Wait,
Because of
wait.
the environmental factors.
Oh,
Could we approach for just a moment?
yes.
Thank you.
I'm sorry, I forgot where I left off. Can I ask the court reporter to read back where we were, Your Honor?
You may.
I kind of feel the same way. Court reporter, do you know what I was going to ask in the
Question,
poll
when dealing
question?
with duct tape specifically, where would you expect to get a profile? Where would you expect to get a better chance of getting a profile, the outer portion for the person applying the tape, or the inner portion where it might be attached to someone's face, saliva, and other bodily fluids might be getting on it?
Can you answer that question, ma'am?
Yes.
Okay.
The higher likelihood of where the DNA profile would be generated from would be from the underside, where it's actually coming into contact with an individual's face, saliva is being deposited on it, so there's cellular material coming from from saliva.
And if it is attached in a violent manner, it would also have skin tissue attached to it, would it not?
I'm not sure that I understand the violent manner.
If it was put on firmly, tightly, that would have skin tissue on it, correct? Or you would expect to find skin tissue on it?
Well, just the contact from the tape being placed on on a person's face. You think about the adhesive, and just like when you pull a Band-Aid off, that hurts, and it's what you think what it's taking with you are part of the cellular material on that topical surface of your skin. So you think about the same adhesive contained in a piece of duct tape being placed on the face. The same type of adhesive is taking place with the contact.
Okay. And did you test the adhesive side of the duct tape?
Yes, I did.
And was there anything that you were able to find there?
The information that was generated was inconclusive.
Okay. Were you able to find was there a readout at a D3 marker?
There was a peak detected at the D3, yes.
Okay. And can you write down or tell us what number that peak came to?
Yes.
You can just say
Okay, it's a 17.
17. Do you know if Kaylee Anthony is a 17 at the D3 marker?
I'm going to take a moment just to retrieve my profiles.
There we go. There we go. There we go. There we go. No. Did you ask in the chat next poll if the chat thinks they're being dazzled?
At D3, Kaylee Anthony is a 14-15.
Okay. So she does not have a 17 at that.
No, sir.
And if you had a 17 at a D3 marker and she is a 14-15, could you exclude Kaylee Anthony as being a contributor to that?
Yes, she does not have a 17 at that location.
Okay. And what about Casey Anthony?
Casey Anthony is a 14-15 at the D3 location.
Okay. So she also does not have a 17 at the D3 marker.
That's correct.
Okay. And when you have one marker that does not match an individual, can you exclude them from being a contributor to that DNA?
Yes.
Where did my list go? Oh, here it is.
Were you given the DNA profile of anyone else other than members of the Anthony family?
Yes, I was.
Okay. Who else were you given?
Oh my goodness.
Are there evidence?
No, they're not, Judge. I'll withdraw the question.
Okay, thank you.
Hurting. He's really struggling here.
Okay, I guess that's everything that concludes the March 19th report, correct?
Yes, sir.
Okay, let's move to your next report on July 24th, 2009. Just take your time. Let me know when you have it.
Take
Can
your
you
time.
repeat the dates again, please?
Yes, July 24, 2009. I believe that's from my draft, but you have it as August 19th of 09.
Yes, thank you.
Okay. Okay. Can you identify to the ladies and gentlemen of the jury what items, the first item that you received on this report?
Yes, the first item that was received is identified as Q80, which was a pair of shorts.
Okay. And for the record, this is State's Evidence 269. And where did these shorts come from?
These shorts, the shorts were identified as items from the medical examiner office.
Okay. And what tests were done on those shorts?
On the Q80 shorts, the item was examined for the presence of blood and semen.
Okay. And what were the results? Were you able to confirm blood or semen on the shorts?
No, both of those tests were negative for the presence of blood and semen.
Okay. And then on, what's the next item that you received?
Q81, which was identified as clothing.
I'm sorry, we're going a little too fast.
Sorry.
It's my fault. Okay, and when you refer to clothing, you're referring to the item which would include the shirt, which was like the elastic portion of the shirt and the letter writings of a child's shirt?
Yes, I can read my description if that would assist.
That would be better. Go ahead.
I have it identified as containing letters, stitching, and stretch material with the letters being spelled or containing BIGTROUBLE.
That's so sad.
And there was also some stick and other debris contained with that item.
Okay. Were you able to confirm blood on that item?
No, I could not confirm blood on that item. The chemical test for the possible presence of blood was positive. However, there was insufficient quantity to continue on and confirm the presence of blood.
Okay. So you can't say in any way that there was blood on there?
Only that the possible presence of blood, that it was positive for the possible presence of blood.
Okay. And was that tested any further?
Specimen Q81 was continued on for DNA typing.
Okay. And out of that, what you thought was possible, were you able to come up with a profile?
No, sir, there was no DNA obtained from that item.
Okay. And on what's the next item?
The next item is Q82, which is identified as a blanket.
I'm sorry?
It was identified as a blanket.
Okay. And on the blanket, were you able to confirm blood on that blanket?
Could not confirm the presence of blood. However, the chemical test for the possible presence of blood was positive.
Okay. And did you then take it a step further to see if there was DNA there?
Yes, that item was swabbed for DNA testing, and no, there was no DNA profile generated from that specimen.
Do I still have lipstick on from last
There
night?
was an additional chemical test also performed on that blanket.
Okay. And what other test was done on that blanket?
That item was also looked at for the presence of semen.
Okay. And did you find any?
No, that item was negative for the presence of seminal fluid.
Okay. And the next item?
The next item is Q84, which was identified as a laundry bag.
Okay. And that laundry bag, what test did you run on that?
The chemical test for the presence of blood was performed on that item, and it was positive for the possible presence of blood. However, there was insufficient quantity to continue on for a confirmatory test.
Okay. And did you then take it a step further and try to get DNA?
Yes, sir. DNA typing was attempted on that item. However, there was no DNA typing results obtained.
Okay. And then the next item.
But it wasn't an expert witness. Like, this was someone who actually
The
worked
next item is Q103, identified as a
on
blanket.
this. You know what I mean?
And
Like,
what
it
test
wasn't.
did you run on that?
That item was
Sorry, when I hear expert witness, I think of like, hey, lady in Miami with hotshot forensic pathology consulting firm. I'd like to hire you to come to the most ridiculous trial to ever take place in my state. I will pay you an absurd amount of money if you testify particularly if you testify in a way that agrees with my findings as a defense attorney. Let me know, circle yes or no. Okay, thanks, bye, click. I mean, she worked on it, you know? I don't think of expert witnesses as someone like who worked on the case in this capacity, but that could just be a perspective thing.
Tested for the presence of blood and semen.
Okay, and what were your results there?
The chemical test for the possible presence of blood was positive on the blanket, and the tests for the presence of semen were negative.
Okay.
Interesting. I got you.
Okay, and
I'm picking up.
can you give a better
now.
description of, actually, if I can have a moment to prefer. Your Honor, my apologies. The blanket that was just described is not an item that's in evidence. It's completely unrelated, and I wanted to move to strike that on my own.
Woof.
And the references to that.
This would be as to which Q number?
Q103.
So I agree the jury should disregard any discussions about Q103. It has nothing to do with this.
And it's completely my error. Mr. Ashton and I had spoken previously in the process of going
So that's the blanket that she's just testified to?
Correct.
Ladies and gentlemen of the jury, you're hereby instructed to disregard testimony that the witness has given concerning the blanket that she's just testified to and not utilize that in the decision-making process in this case. You may continue. Thank you, Mr. Bias.
Thank you, sir. Ms. Subert, there are other items on your on your report that are not in evidence, so I have to ask you specifically for which ones, okay?
Yes, sir.
And testify only to those. Can you also tell us about Q244?
We identify that with the
Yeah.
numbers of
How?
That is,
How is like, did he get in trouble for that? Because he should have.
States Exhibit HR. Can you tell us, give us a description of Q244?
Yes, Q244 was identified as a doll that was received at the laboratory.
And where does the doll, where were you informed the doll came from?
It's identified that the doll was collected from a vehicle, and I can check my notes to determine what vehicle specifically.
Sure, go ahead. Can we both still hear the 125?
Okay.
Your Honor, we have a stipulation that the doll came from the interior portion of the car on the car seat.
Which car?
The Pontiac Sunfire.
Okay.
In the car seat, in the back seat, passenger of the car.
Yes. Okay. Can you tell us what you did with that piece of evidence?
That item was generally swabbed for the presence of blood, and that test was negative. So there was no blood identified on that item.
Okay. All right. I want to take you now to your next report, which is December 16th of 08.
Thank
Is
you
that
to
a long
whoever's
report?
hitting the heart.
No, I believe I'm just got a couple minutes and then we can take a break. Take a
Okay,
break.
go ahead.
I'm aware we're close.
Please make sure to hit the like button and subscribe to the channel. I do this Tuesdays through Fridays.
Sorry, can you state the date one more time on
Yes,
that report?
December 16th of 2008.
report in front of me.
Okay. On page 2 of your report, were you given the profiles of Cindy, George, and Lee Anthony?
If I may refer to one
Yes,
other.
go ahead.
I can't believe that they spent all that time testifying on that item that wasn't even in evidence. Like, what?
The question that you had asked was if I had been given the profiles from Cindy, George, and Lee Anthony.
I'm sorry, buccal swabs from them.
Correct. The buccal samples had been submitted to the laboratory under communication dated October 20th of 2008.
And you, and I'm referring to State's Evidence 113. Were you asked to conduct a paternity test for Lee Anthony as to Kaylee Anthony, being the potential father? Kaylee Anthony.
You may.
This is a hard first day for
We're going to
him.
recess for lunch. I'm going to ask you not to discuss this case among yourselves nor with anyone
You
else.
get a verbal beatdown.
Enjoy your lunch.
That's the first time I've seen that man walk.
You may be seated. Okay, Mr. Ashton.
Your Honor, counsel has no good faith basis for asking this question. He is aware, fully aware from depositions that the FBI laboratory does not perform paternity testing, that they were never asked to perform a paternity test on this case. And in fact, well, I'll let counsel respond and deny either one of those things I just said.
What is your good faith basis for asking the question that you were asking? Just a second.
2 things. Yes, sir.
Just a second.
He's like, let's talk.
Pardon? I was going to find it, but if you can find it quicker than I can.
You are wrong. Second.
Were you asked to conduct a paternity test for Lee Anthony as to Kaylee Anthony, the potential father of Kaylee Anthony?
I have 2 very good faith reasons for asking that question. Number 1, it was tested to see if Lee Anthony was the potential offspring, if Kaylee Anthony was the potential offspring of Lee Anthony. And number 2, I asked this witness last night. The FBI does not normally do that, and that's what she will testify to, that they don't normally do them, but they can do them, and they did. And as far as the statistical analysis portion, they would have to refer it out to a second laboratory. So that's exactly what the objections raised by Mr. Ashton are not true. The FBI in this case did do a paternity test, but he was excluded as the potential father. And end of story. I don't understand where, if it's in black and white in an actual report, how that's not a good faith basis. And I also mentioned this when we were at the break, the items of evidence. I would assume that Mr. Ashton, knowing that it says that in this report, and we identified the actual item, that it was an area I was going to inquire about.
May I ask the witness a question, Your Honor?
You may.
Were you ever asked to do a paternity test to determine if Lee Anthony was the father of Kaylee Anthony by the state or by Orange County or by law enforcement?
If I may refer to my communication log for the conversation that I had with the special agent in charge before I answer that, to be clear.
Go right ahead.
You may.
Thank you.
This is a whole bunch of tomfoolery.
I have the conversation here noted, if I may read that to answer that question. On September 12th of 2008, I spoke with Special Agent Nick Savage. The inquiry about paternity testing / reports, I let him know we could run sample, generate results, and send our report to a laboratory for the statistical component. And this is referring to the lab. It has been a lab that has assisted us in the past, and he agreed. They do not have the sample yet. And that's
Does that in any way mention Lee Anthony?
no, sir. Not in that particular conversation, no, sir.
Your Honor, that is my objection. While counsel is correct that by looking at the DNA profiles that were run, Mr. Lee Anthony and George Anthony can both be excluded as potential fathers for Kaylee. But to ask that question, suggesting that law enforcement specifically inquired, is not a good faith question. If he wants to bring out that, in fact, coincidentally, these test results exclude them as the father, that's fine. But to suggest by that question that that request was made by law enforcement, there is no good faith basis for that. And also, of course, it's hearsay. What a police officer may or may not have suspected or had question about is not relevant in this case, and counsel has no good faith basis for believing that it is.
May I inquire as to the witness, if it's
You may.
necessary? Who did you understand they wanted you to compare the paternity test for?
Before I answer that question, there is one more entry that I wanted to read prior.
Go ahead, ma'am.
Go ahead.
So on October 8th of
Get it
2008,
out.
I also had an additional conversation with Special Agent Savage. And within that conversation, he would like us, it is stated, he would like us to submit the brothers' results with Kaylee and Casey to the UNT lab. A possibility of parentage is present in the results.
So it was your understanding that you were to determine if Lee Anthony was the father of Kaylee?
The question had been posed if we could run the samples and generate a result and do a comparison. Specific to paternity testing, our laboratory does not perform. However, we could have made the determination as a possible biological offspring or excluded as a possible biological offspring, and had identified the laboratory that would perform the statistic component if that had been a possibility.
So you run the test if he's a potential, if he's potentially the father, it would be sent off to another lab for the statistical component.
For this particular discussion, that was what had been laid out for this particular, these samples.
And in your report, do you report out that that based on the SDR typing results, the DNA obtained from specimen Q18-1, Kaylee Anthony, could not have originated from a biological offspring of the individual represented by specimen K9, Lee Anthony?
Yes, that is stated in that report.
The objection then is, what is the relevance of what a particular FBI agent thought or a question that he had? What is the relevance of that other than to suggest to the jury that there's some information out there that this jury has not heard? How is a good faith basis relevance of that?
I never asked that question, Judge. I'm going through her results like I have, and through the work she's done in this case. That is part of the work she's done in this case.
That is not the question counsel asked, and he darn well knows it. If he wants to ask this witness whether Mr. Lee Anthony is excluded as the father of Kaylee, that's fine. That's in the report. More power to him. But that wasn't the question he asked. That wasn't the implication he was trying to leave with this jury.
Anything else, folks?
Not really.
Let me say this. I don't know what was in your mind. I don't know what was in Mr. Ashton's mind.
Ooh.
But you are not to ask questions that may lead to inference that unless you want to call a law enforcement officer to ask that he specifically asks to have something tested, you can get the results as Mr. Ashton has indicated. That's a proper question. I'm not going to even venture a guess or speculate on the motivations or whether or not your question even suggested that. I would do what I told both sides to do some time ago. There's a case called the Almonte Banana Company.
Oh my God.
Which is found at 466 7th 2nd, page 1167. Read it. It talks about good faith basis for asking questions. There's another case, Broxson
He's
versus
such a good
State,
judge, though.
which is found at 505 7th 2nd, 1361, out of the First District Court of Appeals. Please read those two cases for a good faith basis for asking questions. And that's all I'm going to say.
You know that they didn't go do that.
If there are exhibits you need to line up for afternoon witnesses, please let the clerks know so those exhibits may be pulled. We'll be in recess until 1:30. Yes.
You have a motion to strike. I'd ask to strike counsel's last question and have the jury, when they return, be instructed to disregard the question.
Folks, I will look at the question, but all I'm going to say is this. I don't have a hearing problem. And the amplification of questions, objections, I don't need them. Okay?
Okay.
I can hear in normal voices.
Okay. Okay.
I will ask the court reporter to mark the last question. I will review it when I come back, and I will consider that. Okay, we'll be in recess to 1:30.
Okay.
You may be seated. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorney. Is both sides ready to proceed?
Yes, sir.
Okay. Now, do we know what your next question is going to be so we don't?
Well, that's the, I want to know, I don't want any issues, so I want to know how the court.
The last question you asked you asked the following question before we went to sidebar. Were you asked to conduct a paternity test for Lee Anthony as the Kelly Anthony potential father of Kelly Anthony?
Yes, sir.
Okay.
That's what I believe she was asked to do. I don't know if.
And Mr. Ashton, your objection, sir.
The objection is it is not relevant whether anybody asked that question. The relevant is whether a test was done and what the results were. The question. So go ahead, sir.
One at a time.
My apologies, sir. That was my fault.
No, you go ahead.
I can rephrase.
Go ahead. You go ahead.
I can
My
rephrase the
bad.
question. Did you conduct a paternity test for Lee Anthony? Not. I won't ask if she was asked.
Okay. All right. Since we're now all on the same page, let's return to jury.
Since we are not screaming like banshees anymore, let us bring back the
Okay,
jury.
state recognized presence of jury.
Did you heed my previous
And the
admonitions?
defense?
Yes, sir. We do.
Okay, members of the jury, did you heed all of my previous admonitions during the noon recess for lunch? Okay. Apologize for starting late, but we had elevator problems. All right, Mr. Baez, you may continue, sir.
Thank you, Your Honor. May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Ms. Subert. I'm sorry.
Good afternoon.
Where we left off, I wanted to ask you if you conducted what would be considered a paternity test to determine if Lee Anthony was the biological father of Kaylee Anthony.
Hot take.
Can I have the date of that report one more time?
Sure.
That we're discussing.
That's December 16th, 2008.
Welcome, by the way. Make sure to like the stream. We let all.
And you said
people
December
talk.
16th, 2008.
That's what I believe the date. Yes, that's the date I have. And I would be referring you to page 2 and 3, specifically 3 of your report.
I'm trying to shake up a lip gloss.
I apologize. I had that
Kinda
report
old.
out earlier prior to the recess, and I'm just trying to find that one again. I apologize.
It's my absolute favorite color. It looks great on top of red lip color. Just trust me. I know you're like, I would never friggin' put that on in my life. You would. If you were to have like this
I
color.
have
on
the
your
December
lips.
16th, 2008 report in front of me,
Beautiful.
and you're directing me to page 2.
I believe you start on page 2, but the results of your examination are on page 3.
The report I have dated December 16th, 2008 does not address the question that's.
I know you have 2 reports that. You might look up the other one.
Yeah. It's really pretty. Just gives a slight pink hue.
Would it be okay if I looked at the report that you had in front of you?
May I approach
Take
it,
off.
Your Honor?
Your Honor.
Thank you.
Because it's old.
Yes. Go ahead.
My other lippies are fine though. Hey,
And
guys.
can you read to the ladies and gentlemen of the jury, page 3, with your results?
Yes, on page 3, it states, based on the STR typing results, Based on the STR typing results, the DNA obtained from specimen Q18-1, Kaylee Anthony, could not have originated from a biological offspring of the individual represented by specimen K9, Lee Anthony.
May I push the witness?
You may.
So that's her brother, for those of you that don't know.
Now, these types of tests are not done very often at the FBI laboratory, are they, ma'am?
Objection, relevance.
Relevancy?
Just explaining the evidence a bit more, Judge.
Sustained.
Okay, let's move on to that same report, which
I don't
you
know
don't
what
have.
you're referring
May
to,
I approach the
maybe.
witness again? You
Right.
I have found it now. Thank you.
Can you explain to the ladies and gentlemen of the jury what Q47 is? And just for the record, the defense and the state have entered into a stipulation to discuss these items without objection.
Does Q
Yeah, that's no.
47 have a reference exhibit number?
It would be identified as, and we would stipulate that it is the car seat, which is shown in the photographs from the Pontiac Sunfire.
Okay, thank you.
Can you tell the jury about the car seat? What you did?
Yes, I can. Q47 was identified as a car seat from the 1998 Pontiac Sunfire, and that item of evidence was examined for the presence of blood, and the chemical testing performed was negative.
Did you do anything further beyond testing for blood?
On Q47, the car seat, no, I did not.
Okay. And Q48, can you tell the ladies and gentlemen of the jury what that is?
Q48 was identified as the steering wheel cover.
And what did you do with that item of evidence?
The steering wheel cover from the Pontiac Sunfire steering wheel. So the jury knows what we're talking about.
On that particular item, it was visually examined for the presence of any biological stains. And through the visual examination, there were no biological stains observed. So therefore, no chemical testing was conducted.
Okay. And Q55 and 56, can you identify what items they are and where they came from?
Yes, Q55 was identified as debris from the spare tire wheel well. And Q56 was identified as a swab.
Everyone, sorry to interrupt. This is Peggy. She is our beloved watcher from a assisted living facility, and she is my hype girl, and she is just absolutely fantastic. So make sure to say hello to her in the chat. Thank you.
From the spare tire wheel well.
Okay. And other than the other report that we covered that
This
is
was
dated the
disparate.
16th, which deals with identifying Kaylee,
2 streams ago.
have
I
we gone
did.
over all of your reports?
Yes, sir.
I have no further questions for Ms. Summers.
They tested her bone.
Cross-examination?
Good afternoon.
Hello.
I want to take some time and go through what these results mean or don't mean. Let's begin with the Exhibit 15 in evidence, which is identified as the swabbings from the spare tire cover. All right. You indicated that you did a phenolphthalein test on that, which is a presumptive test for blood.
That's correct.
What does the phenolphthalein test actually react to in blood?
It is actually reacting with the heme portion of the blood.
And when you say the heme portion, can you let us know what you mean by that?
Sure. It is part of the substance that's carried along on the red blood cell that we're actually looking for. And it's basically a test where it's able, an oxidation reduction test. I know it sounds kind of technical, but it's a test where the first chemical that's applied is going to react with the heme. And then once you add the second component, it actually oxidizes it, causing that color change if the heme portion is there and is present.
And is the heme portion only found in intact red blood cells?
Well, it could certainly, if you had some broken down red blood cells, if it's still attached there, you could have some residual that could be present. But as you start to break down the red blood cells, you're starting to then also break down the heme portion that's present.
So when a body decomposes, blood decomposes, the hemoglobin also decomposes.
That would be a correct assumption, yes.
Is this test in any way indicative of
What's
whether a
up?
certain substance is fluid of decomposition of a human body? Is it sensitive to that, other than if there's whole blood cells?
Not sure if I understand.
Let me rephrase it. That was a little sloppy. Would this test react to other substances in the body like fat?
If there was any type of presence of that heme portion from the blood that could be connected when you talk about where fat is deposited, it is possible.
Okay, but only if there's relatively intact red blood cells.
Correct.
But if the blood cells have decomposed, then it wouldn't react.
I would never.
Or it's less likely to react.
Less likely.
Ever.
Okay. I guess what I'm getting at is,
I mean, I wouldn't.
the particular stain that you tested has been identified as being decomposition fluid. Fluid from
Objection, Judge. Assumes facts, not in evidence.
I think that's part of New Year's for Americans.
Has been identified as a stain from fluid from decomposition of a human body. Does your
Objection misstates the facts, Judge.
Overruled.
does your test refute that?
Well, I can't speak to whether or not there was a blood or decomposition fluid present there because my test is negative. So I can't.
All we can say is your test did not detect whole blood cells.
It didn't react with any type of substance that was present there. Whole blood cells that maybe were, as we talked about, partially broken down. So I have nothing that would indicate that there was blood contained on those items.
I know.
But you
you
indicated
know.
it could be
I know you
decomposed
know, silly.
fluid, including decomposed blood that might not react.
Just have to say
Well,
that
the
for
test-
legal purposes.
It's the testimony of the witness.
Just-
Witness never testified to such a thing.
Objection sustained. Rephrase your question.
Whew,
I guess what I'm trying to figure out is, does your test
sir.
indicate that the stain was not the fluid from a decomposing human body, in your opinion?
Based upon my testing results, it's negative. So I can't testify to anything other than the evidence that was there that I tested was negative for the presence of blood, which I can't state anything other than I didn't detect any biological material, blood, or other fluid based upon my results.
Could the stain still be decomposition fluid?
Overruled.
As far as if there were other biological fluids that could have been present in there, it's possible.
Okay.
But based on my test, I can't say anything other than it was negative.
All you can say is it wasn't blood.
Correct.
Okay, I've got that straightened out. Now, what happens
Don't be a
to
dick.
DNA when cells decompose?
2026. Don't
Well,
be
as
a
cells
dick.
decompose, the DNA is going to start to also be degraded. Because if you think about where the DNA is housed inside the nucleus of a cell, if the cells start to break down, eventually it's going to get to that center portion, the nucleus, which is also going to cause the DNA over time to also start to be diminished, losing the information that's present.
And in order for DNA testing to work, you have to have intact strands of DNA.
Right. With the 13 locations that I examine as a part of my analysis, if I have portions of those locations still present on the chromosome, I may be able to obtain a result.
But generally with decomposing cells, you don't generally expect to find DNA.
Sustained.
I'm sorry, Yon, I don't believe she answered that exact question.
Oh,
It is cross-examination, Judge, so I would ask for some leeway to get,
One more time.
if I get a court order, read back the question.
But generally with decomposing cells, you don't generally
Let's
expect
get
to
my
find
butt
DNA.
Right. As the body breaks down, that information that's housed in the nucleus of the cell is also going to start to break down. And so the likelihood of obtaining a DNA result does start to diminish as the body starts to decompose.
Now, I want to go to this.
Happy New Year, Nicole.
Sure, I don't think I
Thanks
need to
for
step
stopping
down.
by again.
I want you to clarify for the jury what this result
Right,
means.
Daniel.
Yes, you may.
This result that council wrote on this chart is 50, I guess 55 was the RFU. What does that really mean?
Okay, so the two numbers that are circled there, the 50 is what's referred to as the peak amplitude threshold, or the first level of detection for what's considered a peak in the FBI laboratory's DNA analysis unit, which is based on validation and testing to support what's a reliable result in the laboratory. So during the capillary electrophoresis process, when the DNA is injected into the capillary column and the DNA strands are traveling through that capillary column, at the end, there is a laser. And those DNA strands have been tagged with a fluorescent tag, which enables then that laser to detect the signal of that DNA strand as it passes by. And that's the fluorescence that's then collected. And that's the end result, that DNA profile, based on how much fluorescent was detected at each of those locations, which is then generated into the peaks that we talked about at each of those locations. So at 50 RFUs, that's when the computer interprets if there's enough signal there to determine that a peak can be called. That's the first initial, it'll flag it as a true peak. And that is based, again, on the parameters that we've set at our laboratory to determine it is a peak. The next level.
Let me stop for a second, because I wanted to ask you specifically about the 55 peak that Mr. Bias was asking you so much about. In the context of this evaluation of this evidence, what does that mean, if anything?
A peak at 55?
The one you talked about the amylogenic peak at 55.
So a peak at 55, depending on which location it's detected at, and in this case was discussed, it was at amylogenin. Again, there's a peak detected, but it's only a sole peak at amylogenin. And so based upon the information that I collected from that, determined that it was inconclusive. I cannot give any information about what that peak exactly means.
The amylogenin is a specific chromosome. You're looking at the sex chromosomes, correct?
That's correct.
And this particular result you got is consistent with either being a male or a female. You just can't tell.
Well, the only part of that sex chromosome that's appearing is the X. There is no Y. And it is such at a limited level, I felt it was more conservative to say it was inconclusive. There is just information about one peak there, but is it any information that I can give weight to? I couldn't state that, and therefore I said it was inconclusive.
Now, just so the jury doesn't misunderstand, does this mean that there is potentially an entire DNA profile there that could be enhanced with one of these other techniques that counsel was talking about?
Well, to perform low copy number, that would have to be the initial beginnings at the very start of the DNA analysis. So that would be an enhanced DNA process that the time I was in casework was not being conducted. And so if you were to take that same sample and perform a low copy number technique on it, I don't know what type of result would be generated. I can't speak to that.
It would be complete speculation to say that this would mean anything.
I don't know.
But even if this were enhanced to a readable portion, it would only tell you whether it was male or female.
Again, I don't know. It's possible, but I don't know.
Okay, there was a discussion about a single result on the sticky side of the tape at a 17 loci. Is that correct?
At the locus D3, it was a 17 allele. Again, well below the threshold.
Well below the 200 threshold.
Correct.
All right. Was there one of the individuals that you tested at the laboratory who had contact with the tape?
Yeah.
Yeah, I'm getting kind of lonely up here.
Okay, ladies and gentlemen of the jury, I'm going to permit Mr. Baez to ask an additional question that will provide some type of clarity to the issue. You may proceed.
Thank you, sir. Ms. Subert, we're talking now about the 17 marker, the 17 allele that is on the D3 marker on the sticky side of the duct tape.
Okay.
Okay. When you saw this, did you attempt to eliminate other individuals other than Casey and Kaylee Anthony?
Yes.
Okay. And what did you do to attempt to do that?
The same process that I did with the top side of this tape, I would have done with the underside of the tape, where I would have compared that type at that one location to all of the reference samples from the laboratory personnel, in addition to the known samples that had been submitted as part of the case that I mentioned previously.
Okay. And this is a little different because you only had one marker, correct?
That's correct.
Whereas with the other one, you had 6? Just clarifying it all up, Judge.
Let's get to the point. Objection overruled at this point.
You can answer the question.
Correct. On the top side of the tape, there were results at 6 of the loci or locations or markers. On the underside of the tape, as far as the locations for the STRs, there was a peak, as Mr. Baez has pointed out, a 17 that was present at the D3 locus.
And how many people did you go through? How many people did you look at to see if they had a 17?
I went through the 5 known samples that were submitted as a part of the case, or the profile that was generated for Kaylee Anthony, the known sample for Casey Anthony, the known sample for Cindy Anthony, George Anthony, and Lee Anthony. And then I compared it to the known reference samples that were from the laboratory staff. And there were a total of 5 individuals from which I collected a sample from, and a DNA profile was generated for them.
And did you find someone that could not be excluded?
Hello, welcome.
Again, based upon the report language that I utilized, I did not draw any conclusions to the information at that location. Based on my report, it says that that information was inconclusive and was not utilized for comparison purposes.
So if I understand you correctly, it doesn't meet your threshold to either include or exclude anyone.
It was very limited, so I didn't feel that it was suitable for that comparison, to report out a comparison in my report.
Was there another individual that had a 17 at the D3 marker that you looked at?
There was an individual, as a part of their DNA makeup at that particular locus, the D3, they did have one of their alleles was a 17.
And if you do send a dono through Cash App or Venmo,
Okay, and what did that
let
person
me
have
know.
at the D3? What were there?
The DNA makeup at that particular location for that individual was a 16-17.
However, you didn't see any 16 at the D3 local from the duct tape, did you?
This goes beyond what the court allowed across the universe.
What?
I don't
What?
believe so. This is clearing up the issue, Judge. This is what I would have done.
But if you're watching on a vertical stream and you do want to send your support monetarily, you can send Jules. Thanks.
Under direct.
You may continue.
There was, what was on the duct tape, there was no 16, correct?
The peak that there was just a 17 that was at the level of detection for a peak.
So
They were peeking.
just so the ladies and gentlemen of the jury can understand, this could be 2 things. A person can have,
Explain it to me, Jose.
or a person can have 1 peak, like you had described earlier, correct?
Correct. You're either a heterozygote or a homozygote. Heterozygote having 2 peaks, like you referenced, or a homozygote just having the 1 peak.
Okay. And the person that is a lab personnel is a heterozygote, meaning they have 2 peaks.
That is correct.
But all you found was 1 peak.
Yes, and
1 peak that was reported, correct.
Now, because it's so low, you can't make a determination at all as to either way, correct?
That's correct. As I stated, it was inconclusive for reporting purposes.
But what you can definitely say is that there is no 16 at the D3 marker for that peak.
Using the thresholds that we've discussed from the FBI laboratory, that is correct.
I have no further questions.
Okay, Mr. Ashton, you may continue.
The reality of it is that this peak really means nothing. It's inconclusive. It
Oh.
really shouldn't be taken to mean anything. Isn't that really the reality of this?
And that is the result that I provided in my report, that it was the results for that were inconclusive.
And the reason for that is because at those low thresholds, you can drop out alleles. In other words, you can have someone with a 16, 17, but the 16 is so low it doesn't appear.
like 7.
That's correct, referring to stochastic effect, where you have alleles that may be there at one amplification, and you may not get the same result at the next amplification because it is such a low level of DNA.
And that's why the scientifically responsible attitude toward this is simply, it's inconclusive. It doesn't mean anything.
That's correct.
But if it meant anything, it's not the DNA of George Anthony, correct?
At that particular location, Mr. Anthony did not have a 17.
Okay. Now,
Okay.
Mr. Ashton, may I ask one question?
Sure.
Would that be okay, Judge?
Oh,
I just want to be clear, the DNA types that we did talk about earlier about the same tape for Kaylee Anthony and Casey Anthony, I just wanted to be clear on the types. I think I may have misspoke with
Sure.
the types that were at D3, so I just wanted to be sure the jury was clear on the types that were present, if that would be appropriate.
right ahead.
Kaylee Anthony at D3 is a 14-15, and Casey Anthony is a 15-19. And I think I referred to them both being a 14-15, and I apologize for that.
Now, let's see, we've talked about Mr. Baez spent a great deal of time asking you about blood.
It's
You test
puppy
for
feeding
blood on
time,
items
so
of
I have to
evidence
mute
for the
myself.
possibility that blood was shed during some event, correct?
Correct. That's one of the forensic examinations that's performed in the laboratory.
Testified to. She testified that she tests for blood.
Overruled.
It's one of the examinations to examine items of evidence for biological fluids, and blood being one of them. I cannot speak to possibly how the nature of the substance would get on the item. I'm just looking for it to detect if there is any biological fluid present.
For instance, if someone is shot, there may be blood spattered or bleeding from a wound, something like that.
That's correct.
Or if someone is stabbed, there can be blood, again, gushing from a wound that might be on a piece of evidence.
Sure, that's correct.
If someone is killed in a manner that does not shed blood, the absence of blood doesn't indicate the absence of the crime. Would you agree?
Objection, Judge, calls for speculation and outside this witness's area of expertise.
Overruled.
I'm sorry to
Sure.
make you, could you repeat it one more time?
That's okay. I'm just talking about the significance of the lack of blood on a particular crime scene. If a method is used to kill someone that doesn't involve bloodshed, then the absence of blood doesn't really say it didn't happen, correct? I mean,
Correct. I couldn't, yeah, correct. I couldn't speak to whether or not it happened or not.
Okay.
Right.
Now, let's see, we talked about the items from the trunk. Oh, the tape. Were you involved in any way in the discussions about the order of examination of the tape? In other words, what should come first, second, third, those kind of things?
No, sir.
Okay. It's true, is it not, that you, based upon the history you were given of this tape, would not have expected to find any DNA from the victim on the tape? That's correct, isn't it?
If I may answer without yes or no. The expectation would have been on the sticky side of the tape if it had been, in fact, across the face of the victim. That would be the possible area where I would expect to find DNA. But again, with the information about where the exposure and length of time, I didn't expect that there would possibly, the expectation was neither here nor there. It was a test that was performed. But if there was going to be DNA, the expectation would be that it'd be on the underside where cells would be collected on.
But for DNA to survive on an object in a swampy area for 6 months would be unlikely in your experience. Isn't that correct?
Sustained.
Your Honor, I believe we have expert testimony. May I argue the bench? Because I do.
Yeah. You may proceed.
Let me just ask, how was the area where the remains in the tape were found described to you?
It was described in an electronic communication as being an area that would have water coming into it in a swampy type area.
All right. Now,
That's straight off the Google,
what would happen
Miss
to
Peggy.
any DNA on the tape under those conditions in Florida in the heat for 6 months?
Well, if water was coming in and receding out and drying and humidity, it is probable that if there were cells contained on there, that the cells could start to degrade over time, and the DNA that would be contained in there would also start to be diminished and to degrade.
Okay, thank you. And would that same answer apply also to things such as the shorts or the other clothing items that you were asked to examine from the same scene?
Yes, sir.
Now, in this case, Mr. Baez asked you about something he called a paternity test. The FBI doesn't actually do paternity testing, does it?
No, sir.
In testing the known samples you were given from Cindy, George, Lee, Casey, is it possible, and eventually from Kaylee, correct?
Yes, sir.
And just so we're clear, the sample from Kaylee was the marrow from one of her bones. That's what you ultimately tested.
Beyond the scope of direct.
Overruled.
Is that correct?
There were 2 samples that were processed for the identity of Kaylee Anthony. One was initially a toothbrush, and then the tibia was submitted, which was ultimately the powder from that tibia was utilized to
I said
process
femur. I
and generate a
apologize.
DNA profile.
All right.
Some
And
asshole's going to clip that.
Mr. Baez
online.
asked you about a quote unquote paternity test. What you actually did was look at an existing profile of Lee Anthony, the profile you got of Kaylee, and make a determination as to whether he could be the father, correct?
Right. I generated the DNA type from Mr. Lee Anthony and using Casey Anthony's DNA type, taking the 2 of their DNA profiles and comparing that to Kaylee Anthony to determine if there were alleles present that would suggest those 2 individuals.
And there weren't.
That's correct.
So To summarize all of the testing that we've discussed here, the stain that was in the trunk of the car, all you know is it's not blood.
That's correct.
You can't tell anything other than that.
That's correct. I did not generate a DNA profile either. That's correct.
And the only DNA on anything from
I have not related to any other comment so much. May, like, for real.
the
Too
scene
much.
is explainable by DNA from lab personnel. Would that be a fair statement?
Mistakes
Sounds
of
good,
facts and
girl.
evidence.
Overruled.
Don't fall.
From the outdoor crime scene, in addition to identifying Kaylee, the only DNA profile that was generated from the outdoor scene was that of a laboratory staff member.
No further questions.
Redirect.
Raise Jesus. Oh, come on. Oh, Jose. Come on. You're killing me, Jose.
You testified, Ms. Subert, about decomposition in the trunk and talked about as cells break down, there's no longer an ability to get DNA, correct?
It diminishes over the time period. That's correct.
And that's what I want to ask you about. You can't testify as to at what point during the decompositional phase that you would not be able to get DNA, can you? Except the later stages.
There's many, it's hard yes or no answer, Your Honor.
Answer.
And just explain it away.
Okay.
Go ahead.
So, well, it depends on what exactly, when you talk about obtaining a DNA profile, you're trying to do. Are you attempting to generate a known DNA profile for the identity of that individual, utilizing a bone, utilizing a tooth? Those are the types of body parts that will remain: the skin, the tissue, the blood, and that over time will start to decompose and start to disappear. But the more hardy, for lack of a better word, the hardy areas in the body will remain. But as a body decomposes, all of those tissues, cells, and fluids that are contained within us will start to degrade, and the ability to generate DNA from the collection of those types of cells and body fluids diminishes.
And that happens at the latter part of decomposition, does it not?
Objection, leading.
Sustained. Rephrase the question.
Yes, sir. Does that happen at the latter part of decomposition?
Objection, leading.
Overruled.
When you ask the question at a latter part of decomposition, are we talking, what is the environment for that decomposition that's happening? Is it in a hot environment? Is it a cold environment? Because all of those factors are going to play a part in how the body breaks down.
Right.
And so in order for me to give a scientifically based answer as to where is the period in time that I can no longer generate a result, I can't give you that answer.
You can't say.
I cannot say.
Okay. However, what you can say is that you did not get DNA or blood from the trunk of that car, correct?
That's correct.
And is it your understanding that in the early stages of decomposition, there is blood?
If you think about what's running through our bodies, there's the circulatory system comprised of blood. And so as a body starts to decompose, those fluids are going to start to leak out from the body. So the possibility would exist.
And there's also a possibility that blood would leak onto a carpet of a trunk liner.
Objection, beyond the scope of our expertise.
I think the witness.
Just a second.
Yes, sir.
Ma'am, can you answer that question within the scope of your expertise?
Yes, sir.
Then you would be permitted to answer.
Go ahead.
Well, within the confinement of a trunk, if a body is placed there and it's slowly going to decompose, all of those fluids are going to start to dissipate into that carpet or the trunk liner if that is contained within the trunk and the body is just placed there and not contained with any type of protective material. It would just be placed there as such.
And if it is contained in a plastic bag and there's a hole in the plastic bag in the front where you tie it up, could it leak out of that area? Is it possible?
Sure, it's possible.
Okay. Now, I think I just have one. The summary that you gave on as to the items recovered at the scene, you could only testify to the contamination aspect of the potential contamination of the lab person on the
That's what I
non-sticky
thought, too.
side, correct? Of the duct tape?
Objection, leading.
Sustained. Rephrase your question.
When you gave that answer, you were considering what is reportable through your protocols, right?
Sustain.
Were you taking, let me ask you this way. As you were giving
Just ask
the
a
answer
damn
to Mr.
question,
Ashton in
period.
reference to what you were able to get out of the scene, did you take into consideration your protocols? What your reporting protocols are?
When I gave the answer to Mr. Ashton, I was giving that based upon what I've issued in my FBI laboratory report.
And that's based on the protocols that you're allowed to report out.
It's based on the standard operating procedure of the laboratory, correct?
And the 17 allele that you can't make any conclusions on, you did not take that into consideration when you issued your report on that.
Well, as discussed, that information for that portion of the tape, I could not provide a conclusion to. It was inconclusive. And so in my answer to Mr. Ashton, I was considering what I issued in my laboratory report, and that was a part of it.
And when you discussed about the elements, the outdoor elements, did you consider let me rephrase that. When we were discussing the outside elements and the potential of being able to find DNA, you did say that the expectation, if duct tape were placed around someone's mouth and there was if duct tape was placed around someone's mouth, you would more so expect to find that DNA on that portion than the non-sticky side. Right?
Sustain.
Would you expect to find more DNA on the sticky side or the non-sticky side?
My expectation would be that if there was DNA recovered, it would be more probable or more likely to be on the sticky side.
Thank you, ma'am.
Just one quick question. When fluids leave the body, they continue to decompose, don't they?
Yes, sir.
So even blood that is spilled on a surface, if it's hot or wet, it'll continue to decompose.
Yes, sir.
Thank you.
Oh, thank God, because
Wait,
I
what's the excuse?
was gonna just
Yes.
fast
Thank you, ma'am.
forward if they kept going. Huh. Pictures or it didn't happen. I get it. You can't
Robin
take
Maynard, Maynard.
You may proceed.
Thank you, Your Honor.
But
Ms.
make sure
Maynard,
you,
how are you employed?
I'm the founder and executive director of Libby's Legacy Breast Cancer Foundation.
Oh.
And back in 2008, how were you so employed?
As a crime scene investigator with the Orange County Sheriff's Office.
Okay. And you were the person that actually collected an item of evidence 313 in this state's evidence 313. May I show you a
God.
photograph of that?
Of course.
Your Honor, may I approach the witness?
Yes.
Yes. Yes, you may, darlings. Mm-hmm.
Do you recognize that item, ma'am?
I do.
Okay. Can you tell the ladies and gentlemen of the jury what that item is?
It is a cardboard mat with a pink heart-shaped raised material.
May I publish a copy of that to the jury as well?
You may.
What is
But number what?
wrong with me?
313?
All right.
The photograph is.
The
Oh,
photograph.
the photo.
No
Change a
objection.
lot,
The
but-
actual item is, but that photograph needs to get a
Oh,
separate.
God.
I think the
Just
photograph does
in
have a
time,
separate
not
number.
work.
I can.
Miss Meowgie.
Defense Exhibit W?
Okay.
No objection to its introduction. no.
You want to introduce it?
Yes, sir.
Okay, it'll be introduced as defense number.
Ma'am, when you
Thanks
when you
for the
collect an item of
sound.
evidence like that, what do you do to record where you found it and a description of it?
It's not supposed to be like this.
I was in charge of the sifting operations, and that's quite different than how we would normally collect something because they're coming in, items were coming to the sifting stations in buckets. So for example, a map couldn't be made
I like
in the primary
sifting for
search area
gold
of
ones
items I found because we only had a baseline
Arizona.
measurement. So as buckets would come to the sifting stations, they would have the searcher's initials, the lane number,
Yes,
and the
sir.
coordinates for where that item was. We would sift, and when an item of evidentiary value or items to be collected were collected, I would photograph the item, note on the bucket where it came from, which would indicate to me lane, coordinate, and tell me how many feet that was.
And what lane was this found in?
This item appears to be from lane 6.
Okay. And how many feet from the baseline was it?
I have here in my marker that it was 45 feet west of the baseline.
Your Honor, I'd like to publish Defense Exhibit AT and introduce this with conditions from the state, and I have stipulated that it is not to scale. Is that correct? But it is not to scale, but it's still open.
What says the state?
No objection with that stipulation.
I know
Okay,
that
you'll
you
be
are so
receiving
allergic
evidence
to
as-
me, human. That's why I come over to greet you and make you cough. Oh, don't bite me. Don't bite me.
You wish to publish?
Yes, I do, Judge. I apologize.
No, no, stop.
My apologies. Was everyone, did the jury see the last photograph?
No.
My fault, Your Honor. Apologies. Can I publish?
Coco,
Put that
I
last
need
one
to
back up.
publish the photo.
Which is what?
This is 16, Defense 16.
Okay.
Yeah, you get cat cam without even paying for anything. 'Cause I'm in danger of my life.
I think this thing is breathing.
Stop biting me. That hurt. Don't you want to go outside and play in the snow?
Oh, perfect. Okay. Now, can you indicate to the ladies and gentlemen of the jury where you indicate that it's lane 6, 45 feet from the baseline? Okay. Can everyone see that? Okay. Okay. Now, at this time, Your Honor, I'd like to publish Defense Exhibit AT, which will be admitted into evidence as
Don't
Defense 17.
bite
You might-
me. I'm gonna bite you next time.
Can you show the ladies and gentlemen of the jury where lane 6 is?
Everyone thinks you're all so sweet and just
And can you show the ladies and gentlemen of the jury?
At me?
Let me clear this out.
that's ridiculous.
Oh.
You're about as nice as
Where 45 feet from the baseline would be. And lane 6. Okay. And taking into consideration this is not to scale, where are the areas where the bones were found?
The areas where bones were found in the sifting, there are other items that are not here. The bones that were found through sifting only, this is not in the primary search area, are indicated in a general way where it says bone location. It can't be exact because it came from a bucket that was sifted in a general area that was specific to about 5 to 10 feet.
really?
And that's what's indicated in the white dots.
Correct.
Okay. And is it fair to say that this is just a general, you're not pointing one bone was found at each dot, correct?
No, those are each bones. I believe there were 13 bones that were found in sifting.
Okay.
So based on the lane coordinates, I did a general map when bones were found, and I would collect them where they were located based on the coordinates on the bucket.
Do you know if any bones were found in this area here?
I believe there was a bone found in lane 6, and I'm not certain how many feet west of the baseline that it was.
Okay. Yeah, I have no further questions for this witness, Judge.
So
Cross-examination?
No questions on cross, Your Honor.
May the witness be excused.
Yes, sir.
Thank you, ma'am. You may
Uh-oh.
be excused.
Are they bringing in the forehead girl?
It's Ronald Murdoch, M-U-R-D-O-C-K.
Yep.
You may proceed.
Thank you, Your Honor. Mr. Murdoch, how are you so employed?
Sir,
I work
do you
for
know
the Orange
how?
County Sheriff's Office as
big your
a
last
supervisor
name
in the
is?
forensics unit.
I'm going to ask, you had previously demonstrated that you had drawn up a mapping system through a map through a software system. Can you open that up and because I'm going to ask you to demonstrate something. If you
I
could.
didn't
Would you
show
like me to
this
hook it up
yesterday
as well?
Yes, please.
because it was like so technical, and I did not want to listen to it personally. At least I think this is the guy I didn't show.
Yes, yes.
Can you draw I realize you don't have the exact spot to where the heart-shaped sticker on the cardboard that was attached was found, but from lane 6, 45 feet from the baseline. Can you tell us how far that is from area A where the skull was found?
So 45 feet from the baseline?
Yes. Lane 6. Okay, can we publish, Your Honor, to the jury?
No. I mean, I'll plug it all in the back?
Yeah.
Yes, sir.
Well, it's not up on the screen.
Man, she really scratched me
There we
too.
go.
Okay. You wanted to publish, right?
Yes, sir.
She's all pern, like she's
Can you
happy.
see it, members of the jury?
And how far is the distance from the skull area to where 45 feet from the baseline lane 6 is?
It's approximately 30 feet. Again, that's basing that upon the middle of lane 6 and the approximation of the area in which that was taken, that heart-shaped sticker and that piece of cardboard.
Okay. And how far would you say Q63 and 64, the two pieces of duct tape, were away from the skull area? You don't have a measurement like that, or would you say?
Are those the two items that were on the diagram as duct tapes 2 and 3?
Correct.
Okay. I can bring those up if.
I checked, it's inaccurate.
Are you? So the best that you can give as far as an estimate as to where the sticker found was compared to where the skull was found is 30 feet away.
Yes.
Okay. Can I have you, for the record, mark and give an indication of an X on state's evidence 279? May I approach?
Right.
There.
And what is it that you want me to mark, this location?
Yes.
Okay.
Okay. I have no further questions for the witness, Judge.
May the witness be excused.
Yes, sir.
Thank you, sir. Please retrieve the
What purpose
exhibit.
did that serve? Asking for a friend.
My name is Jennifer Welch, W-E-L-C-H.
Like the green.
Your Honor, prior to this witness testifying, both the defense and the state have entered into a stipulation as to defense exhibit AS, AR, AQ, AP, AO, AN, AM, and AL to admit them into
AIM.
evidence.
What says the state?
AOL.
That's correct, no objection.
Then those exhibits will be received in evidence as defense exhibits.
AS will become defense exhibit number 18, AR will become defense exhibit number 19, AQ will become defense exhibit number 20.
You don't have to
AP will
apologize.
become defense exhibit number 21.
Please make sure to
AO will
like
become defense exhibit
the.
number 22, AN will become defense exhibit
Stream
number 23, AM will become defense exhibit number 24, and AL will become defense exhibit number 25.
Good afternoon, Ms. Welch.
Good afternoon.
You were in charge of documenting the scene off Suburban Drive, were you not?
Yes, I was.
And were there a large number of items that appeared to be disposable waste in that area?
Yes, there were.
Okay. Summed it up without getting too technical, would you consider it trash?
Yes, some of them were.
Okay. And were a lot of these items collected?
Yes,
Okay. I believe you testified previously that there were over 300 items collected.
yes,
Okay. And did there ever reach a point where you just stopped collecting trash?
I recall there
Thank
were
you.
some large items, but I don't recall at what point that was.
Okay. Now, are you familiar with the different lanes and the setup as far as the measurements from the baseline?
Yes,
Pretty sure she.
Can you
explained
tell
it.
me if there were any bones found past lane 6, 45 feet from the baseline?
may I refer to my documentation?
Absolutely.
I would trust her with my life. She seems like she has it together.
I'm having to refer to a printed diagram, and in referring to that, there does not appear to be any bones collected past that location you stated.
And I'd like to show you some photographs with the court's permission of different items of trash and see if you
Yes. Thank you.
would
Patty.
characterize
I
this
agree.
as some of the items that were collected.
Okay.
May I publish, Your Honor?
Yes, please refer to them by the exhibit.
Yes, sir. Defense Exhibit AM.
Have they been remarked?
Okay.
If you head them to the clerk so she can remark them.
Yes, sir.
Oh, I need to check this to share. Shut up.
Does that appear to be, I'm showing you defense evidence 24. Does that appear to be generally what was collected through the area, through the sifting area off Suburban Drive?
I don't recall this being found through sifting, but I recall it being found through searching and clearing of the vegetation.
Okay. Were any of these items submitted to the lab for further testing?
Not that I can recall.
Okay. Now showing you defense 25. Does this also appear to be certain items that were collected?
Yes.
Okay. And do you know if any of these items were sent to the lab for further testing?
Not that I recall.
Actually, let me stop you there. Can you identify what lane this was in based on the photograph?
Yes. As can be seen in the photograph on a card that I had written, these are miscellaneous items collected from lane 4.
Okay. And I'm now going to show you exhibit 23. And does this look like items that were collected?
Yes, it does.
And were any of these items sent to the lab for further testing?
Not that I recall.
And what lane did these come from?
As indicated in the photograph on the card, they are miscellaneous items collected from lane 1.
And so to put it in perspective, I'm going to show you defense exhibit 17 again. Would lane 1 be this area here, this lane?
Yes, as indicated on that diagram, yes.
Okay. And lane 4 would also be indicated there in that diagram.
Yes, it would.
What are you doing, bud?
I'm going to show you now defense exhibit 21. Were these items collected?
Yes, they were.
And were any of these items sent to the lab?
Not that I recall.
And what lane were they found off of?
As indicated in the photograph on the card, they're miscellaneous items found in lane 3.
And could you just point really quick on the prompter where lane 3 is?
Yes.
Okay. I'm now showing you
Okay.
defense exhibit 20. Were these items collected? Let me turn it upside down. And were any of these items sent to the laboratory?
Not that I can recall.
And what lane were these collected from?
As indicated in the photograph on the card, they are miscellaneous items from lane 3.
Can you indicate briefly where that is? I'm now showing you defense exhibit 19.
I think what he's
Do
going
these appear to
for
be items that were collected?
is
Yes.
that there were
And can you make
items
out what lane those were found at?
found in the area
Not in this photograph.
that weren't
I'll move that out.
tested. So that is my interpretation of what's going on right now.
And now I'm going to show you defense exhibit 18. Were these items collected?
Yes, they were.
And were any of these items sent to the lab for analysis?
Not that I recall.
And where does it say this was found?
I can't quite read it in the photograph.
Let's see if I can zoom in
You
a
mean
little bit.
Lacey Texorcist? It's like the Lacey Peterson thing all over again.
Can you make that out now?
Yes.
Okay, where was that collected?
According to the card in the photograph, as indicated here, they're miscellaneous items from the clearing
I knew what you meant.
area east of the wooden fence.
Okay, and where just generally would that be located? From here, if you could just point in the general direction.
Yes, the general direction of the wooden fence would be along this side. I don't recall exactly what lanes it would have matched up with.
Okay. I have no further questions for this witness, Judge.
Cross-examination?
Just one question.
Investigator Welch, would it be fair to characterize the area where Kaylee Marie Anthony's remains were discarded as a trash dump?
Yes, that's what I would classify it as.
Well,
May the witness be
I
excused.
don't think it was trash. It was across from a elementary school.
My name is Lori Gottesman. That's spelled Lorie. Last name is Gottesman.
And how are you employed, ma'am?
Yes.
I'm employed at the Federal Bureau of Investigation, Laboratory Division.
Okay. And what is your occupation at the FBI laboratory?
I'm a supervisory forensic document examiner.
And how long have you been employed there?
I've been employed at the Federal Bureau of Investigation since 1992, just shy of 20 years.
And can you please share with the ladies and gentlemen of the jury your educational background?
Yes, I received a Bachelor of Arts degree in psychology from the George Washington University in Washington, D.C., and a Master of Science in Forensic Science from National University in San Diego, California.
Is that a real place? Is that like a real university?
And what is the nature of question documents? What does that mean?
Well, as a question document examiner, I examine all different types of documentary evidence. That would include handwriting, hand printing, printing processes, typewriting, plastic bags, shredded paper, torn paper, alterations, obliterations, charred
Bill of
documents, and liquid soap documents. For example, I compare those items with question items with known items for the purpose of trying to determine the question item's authenticity or origin.
And what kind of training do you have in that area?
Well, to become a document examiner at the FBI laboratory, I underwent an intensive training program there at the FBI laboratory. The training included classroom instruction, reading from related books and journals. I attended professional meetings. I went and toured factories. I took tests. I had oral boards. And most importantly, I worked actual cases under the guidance and supervision of actual certified document examiners. And
is question documents not just relating to documents, it relates to a whole different field, does it not? A whole different field, different types of materials, I guess is what I'm asking.
Well, it doesn't necessarily need to be on documents. Sometimes writing can be on different types of surfaces. For example, sometimes a person might write a threat on a bathroom wall, for example. So I might examine the writing on a wall, graffiti, that type of thing. So any type of writing might be on a different substrate. I mentioned torn edges or torn items. It could be some type of packaging that needs to be put back together. So it doesn't necessarily need to be a document. It could be other types of substrates that I look at. So it's not necessarily documents, but it's included in the question documents unit.
Okay. And do you belong to any professional organizations?
Yes, I'm a member of the Mid-Atlantic Association of Forensic Scientists. I'm a member of the American Society for Testing and Materials. And I'm also an assessor for ASCLD Lab, which is the American, for ASCLD Lab, which is the organization which accredits the laboratories.
Is that the American Society of Crime Laboratory
Directors, Laboratory Accreditation Board, thank you. I just drew a blank for a second. And that's international. And I think that's it for now.
Okay. Have you ever been admitted as an expert witness to testify on questioned documents in court?
Yes, I have.
How many times?
Well, I'm not exactly sure, but somewhere more than 20, maybe 20 to 25 times.
And has that been throughout the country in both state and federal courts?
Yes, I've testified in federal courts and state courts and also in Canada.
At this time, Your Honor, the defense would move to have Ms. Gottesman admitted as an expert in questioned documents.
No objection from the state.
Ladies and gentlemen of the jury, the witness will be accepted as an expert witness in the area of question document examination. You may proceed.
Thank you, sir. Do you, in the course of your work with certain instruments?
Yes, I do.
Can you name some of the instruments that you work with?
Yes, there's certain tools that I work with regularly in my unit. One would be the ESDA machine, that's the electrostatic detection apparatus, and that's used to detect indented writing on documents. Another would be the video spectral comparator, that's also known as the VSC, video spectral comparator.
What is that? What is that instrument?
That is a tool that document examiners use for a variety of reasons. That is basically a tool that is comprised of a variety of lights and filters, a camera, a computer, and a monitor. And using those different lights and filters, I'm able to see different parts of the spectrum of light and detect different things depending on what it is that I'm actually looking for on the document.
I can have a moment.
And why do we care?
Did you receive any items? I'd like to refer you to your report on December 22nd, 2008. Did you receive any items to test in this case?
Yes, I did.
Okay. And what items did you receive?
At that particular time, I received 3 pieces of tape, actually duct tape. They were identified as items Q62 through items Q64.
And what is your understanding that where these items came from?
It was my understanding that they came from the victim herself.
Do you have your report with you?
Yes, I did.
Okay.
I don't want to do that.
With the court's permission, can you look at your report and see exactly where the items were supposed to have come from?
Yes.
You may.
Thank you. It says that these items were received from the medical examiner's office.
Okay. And these were the items admitted into evidence, Q62 through Q64, which I believe
Could you note,
are.
tripod, please? Pretty please? You're a very pretty puppy. Okay, this is what we're going to do. Executive decision time.
No.
Just like we're going to find out exactly what this note says. And then we are going to the defense's forensic expert. We're not going to the bug guy. I've heard enough about all the larvae and pubulus shit that I need to hear for 2026.
What were you asked to do or to look on these pieces of duct tape for?
The purpose of my examination with respect to these 3 items was to determine if I was able to detect a heart-shaped sticker or a sticker or any remnants from this sticker.
Okay.
And did you use the video spectral comparator?
Yes, I did.
Okay. I'd like to now show you Defense Exhibit AU.
AU, what you doing over
The demonstrative aid. I don't believe we have an objection from the state, Judge. May I?
Is it? Counsel talking about the photographs on that page,
Correct.
not the text?
Correct.
Okay. If she feels that she needs it, then I have no objection to it.
Okay. I'd like to show you certain items so you can explain to the ladies and gentlemen of the jury how this, I'll zoom in, so.
Could we just cover the text part since that's not really before the jury?
Sure.
Because I didn't think that was needed. It's just for that. Thanks.
No problem. Okay. Can I publish to the ladies and gentlemen of the jury, Judge?
Any objection to that being published as demonstrative aid?
No, sir.
Okay, we will publish.
Okay, the VCS, correct? Is that what
It's the
called?
VSC.
VSC, sorry. The VSC, can you explain to the ladies and gentlemen of the jury what they're looking at here and how this machine helps you in the course of your work?
Sure. The VSC, as I briefly explained, has a series of lights and filters. And what it does is it allows our eyes to see things that we wouldn't normally allow it to see. Our eyes as human beings see things between 400 and 700 nanometers. And we see things as different colors. We either see things as white if the light is reflected. We see things as black if the light is absorbed. And we see things as colors if it's a combination of absorption and reflection. That's between 400 and 700 nanometers. If we go outside of the 400 and 700 nanometers into the ultraviolet or infrared spectrum, which is before the 400 nanometers or above the 700 nanometers, where we don't see light, that our eyes can't see it, but using these special lights and filters, we can allow our eyes to see things that we wouldn't normally see. So basically, by putting these documents under those lights and filters, we're able to see things without disturbing the documents or changing the documents that we wouldn't normally see. So basically, this is an example of just putting documents inside the video spectral comparator, which is just a box, and looking at these documents. And you can see with the naked eye, they would have just been white paper, but putting them in perhaps under ultraviolet light, they react differently, where one document is brighter than the other four. So in this particular case, there might have been, say, a 4-page contract or a 4-page will where there might have been a suspected insertion of a page.
Sorry for all.
And in this particular case, one page is different than the other 3. We couldn't see that with the naked eye, but just using some different lights and filters that we wouldn't normally see with our own eyes, and just using this tool to aid us to see something that is outside of that 400 to 700 spectrum, we can see something that we wouldn't normally see.
So if somebody tried to pull a fast one on a will, you could spot it by using this instrument.
Right, it could be indicated that there's a different piece of paper.
Okay. And what does this example here show?
Well, this is an example on our right is shredded paper without any, without using any different light except for normal everyday light. Then if you put it in the VSC, you can see that some of the pieces of shred are reacting differently than other pieces of the shred. And in our unit, we do put shredded paper back together. And so we can use this as a method to sort the paper. So it helps us to put the paper back together quickly if we can sort the pages by how they react. In the VSC, we know which pages may go back together and which pages don't belong together.
Remember that executive decision time? This is it.
No further questions.
Right.
No further questions.
Any redirect?
We were talking about the duct tape, ma'am. You mentioned that you were asked to, that the DNA was going to be compared from the suspects. Did they indicate who the suspects were?
Sorry, objection. Which was asked about DNA comparison in cross.
That's about that. No further questions.
Excused.
Yes, sir.
Thank you, ma'am. You may be excused.
Okay, may I go back to Virginia?
Yes, you may be excused.
Yes, you can go back to Virginia. May we approach briefly before the next witness?
Yes, you may.
My name is Carey Oyen, Caryoien.
Good afternoon, sir.
Good afternoon.
How are you employed, sir?
I'm currently employed as the section chief of the scientific analysis section of the FBI laboratory. Prior to that, I served as the unit chief of the firearms tool marks unit, unit chief of the trace evidence unit, and prior to that, I served as a forensic examiner in the trace evidence unit.
And how long have you been employed with the FBI?
I've been with the FBI just over 15 years.
And what is your educational background?
I have a bachelor's degree in biology and a master of science degree in entomology.
And have you received any specialized training in your field?
Yes, as a trace evidence examiner, specifically, I was a hair and fiber examiner. I received over a year of on-the-job training at the FBI laboratory that involved lots of reading of scientific papers, books, lots of microscope time looking at different hair samples, fiber samples, learning how to identify hairs and fibers, then comparing hairs and fibers to each other and to known samples, oral examinations, microscopic examinations. At the completion of that training program, I was qualified as an examiner within the trace evidence unit, specifically.
Okay, this is going to be our last witness for the day, my little jurors. And if you haven't done so already, please make sure to hit the like button on this stream and subscribe to my channel because it's 2026 and you should know by now that it's free to do that. But if you don't, surprise, cool, let's go.
My name is Dr. William Cesar, C-E-A-S-O-R, Renato, R-A-N-A-T-O, Rodriguez, R-O-D-R-I-G-U-E-Z III.
You may proceed.
Please, court. Mr. Ashton. Good morning, ladies and gentlemen. Good morning, Dr. Rodriguez.
Good morning.
Sir, can you please tell us what your occupation is?
First, for the court record, if I may state, I am here as a unpaid consultant, and my
I am a hostile witness.
Listen closely to the questions and answer only the questions that I asked of you, sir.
Yes, sir.
Can you give us your occupation, sir?
Yes, I'm a forensic anthropologist.
Okay. And where are you employed?
I am employed with the Department of Defense Armed Forces Medical Examiner's Office in Washington, D.C.
And are you here as an unpaid consultant?
I am.
Okay. And how long have you been employed with the U.S. Armed Forces Medical Examiner's Office?
For about 23 years.
Okay. And what did you do before that?
Before that, I served as the forensic anthropologist and chief of operations for the Onondaga County Medical Examiner's Office. That's ONANDAGA, which is located in Syracuse, New York, and was responsible for the forensic anthropology for that office and the surrounding county in Syracuse, New York, and several other counties that we contracted to do forensic services.
Can I get you to put the microphone a little closer to you? Sure. The acoustics are really bad in this room. So, okay. Sir, can you share with the ladies and gentlemen of the jury your educational background?
Yes, I received my BA, MA, and doctorate from the University of Tennessee at Knoxville, receiving my doctorate in 1985. And from there, went on to my first professional employment, which was with the Caddo Parish, that's CADDO Parish Coroner's Office in Shreveport, Louisiana, where I served as the forensic anthropologist and chief deputy coroner for that parish. And as part of my job within that particular office, we served about 2/3 of the state of Louisiana.
Are you a co-founder of the Forensic Anthropology Research Facility at the University of Tennessee?
Yes, I am.
Is that also known as the Body Farm?
Correct.
Okay. How did that get started? How did you start that?
That was actually the idea of Dr. William Bass, who was my chief mentor and professor at the time at the University of Tennessee. We were in his office one day discussing about time since death, which was a question that is commonly encountered forensic sciences.
What year was this? I'm sorry.
This was in the early 80s.
Okay, go on.
And as we were batting it around in the office, we were discussing, how could we get some better understanding of the human decomposition, how it relates to time since death. And as we were discussing it, Dr. Bass said, well, the only way that we could do this is basically actually study the process of human decomposition. And to do so, we needed to start research and experiments.
It was a brilliant idea.
He recruited me into this project to actually build the decompositional facility and start the first research.
Okay. And you put up the fences?
I put up the fences, helped lay the concrete, brought in the first bodies, and began to conduct the very first experiments.
And who wrote the first publications from the
I was the senior author on the first publications.
Okay. And since then, what kind of experience have you had?
My grandmother donated her body to science.
Well, I've had extensive experience in human decomposition as a forensic anthropologist with my 3 years in the Caddo Parish Coroner's Office, where we deal in a very kind of a subtropical climate. Decomposition was quite evident in many of our cases throughout the state, and when we're dealing with decomposed remains because of the heat. And the humidity and the insect populations. And then in upstate New York, I saw similar types of bodies. And then during my 23 years with the government, I've traveled all over the world and looking at various types of bodies and various stages of decays in all environmental conditions that one could possibly think of.
And where have you traveled to consult on well, let me actually ask you this before that. What is taphonomy?
Taphonomy is basically the study of the breakdown of an organism after death, basically what happens to that organism and how it's recycled by nature.
Okay. And do you have extensive research in that area?
Yes, I do.
Okay. And can you give us some examples of some of how many publications have you had on the topic?
I've had two. Initially came from the Body Farm. I have a chapter in dealing with decomposition and forensic entomology in the second edition of Medical Legal Investigations by Spitz and Fisher. And I have given numerous papers on a yearly basis to the National Academy of Forensic Sciences and the National Association of Medical Examiners on various cases involving decomposition.
And how did forensic entomology begin?
Well, basic forensic entomology basically has its roots in Europe, began early in time in America, but it wasn't really that well founded. And it really wasn't until the time of the decompositional research at the decay facility at the University of Tennessee, in which the entomology movement and forensic entomology here in the United States really got started. A colleague of mine that I ended up meeting during that time, Dr. Lee Goff, who's probably considered one of the most eminent forensic entomologists in the country, who's out of Hawaii, was very interested in this research, as well as a number of his colleagues. And we began to meet and talk about our research, since I had looked at insect activity as it related to decomposing bodies. And as a result I helped them found their American Board of Forensic Entomology.
So would you say you have extensive experience in the area of entomology as well?
Yes, as far as insects and being involved in the activity in which decomposition occurs and those insects are attracted in.
Have you lectured in the area of entomology, taphonomy, and anthropology?
Yes, I have on many occasions.
Okay. Have you been admitted in any courts as an expert witness on those topics?
Yes, I have.
Okay. How many times?
Numerous.
Can you give us just a ballpark?
I would say in the realm of 100 or more, conservatively.
Okay. At this time, Your Honor, I would move to have Dr. Rodriguez admitted as an expert in taphonomy, entomology, and forensic anthropology.
May I vote aye on the entomology issue, Your Honor?
You may.
May I just do it from here? How many times have you been qualified as an expert specifically in the area of entomology?
I have not been qualified as an expert in the specific field of entomology, but in the use of insects in determination of time since death and decomposition process.
Your Honor, I have no objection to his qualifications in the area of taphonomy and forensic anthropology, and to the extent that insects are involved in taphonomy in that area. But in entomology generally, I do object.
Your Honor, he has testified that he has helped establish the American Board of Forensic Entomology. The research that began entomology came from his.
Approach the side, my folks. You may proceed.
Thank you, sir. Dr. Rodriguez, can you tell us a little bit more about your experience in forensic entomology?
Well, again, early in the decompositional research that was conducted at the Body Farm, my primary...
put the microphone a little closer, sorry.
My primary area of study was looking at the insects and documenting the various insects that inhabited the body, their activity on the body, their reproduction on that body. And throughout my career, I have worked extensively with forensic entomologists in looking at this similar activity, collection of the insects, and an instruction to law enforcement on how to utilize and collect these insects in relationship to the decompositional process and utilize them for things such as time since death.
How many times have you consulted with law enforcement in the area of forensic entomology?
Hundreds.
Your Honor, at this time, I would move to have Dr. Rodriguez admitted as an expert in forensic entomology, as well as the other areas.
As I indicated, I have no objection to him testifying as to entomology as it relates to decomposition, but the broader field of entomology I would object to.
The witness will be accepted as an expert witness in the area tendered by the defense and may continue.
Yes, sir. Sir, what information have you been given, or were you given in this case to review?
In this case, I will receive the documents and records pertaining to the medical examiner's report and findings of the examination of the deceased. I received the forensic anthropological report and their findings regarding the deceased. I also received the entomological report that was generated by Dr. Neil Haskell. And I also received photographs of the recovery and the scene, in addition to the photographs that were taken of the remains of the deceased at the medical examiner's office.
Now, did you also examine photographs of the medical examiner that they took at the medical examiner of the skull?
Yes, I did.
And also at the scene?
That's correct.
Okay. Tell the ladies and gentlemen of the jury any opinions that you may have that have to deal with the collection of the evidence at the scene.
The evidence collection appeared to be very thorough as far as collecting the skeletal remains anytime you're dealing in particular with the remains of a child, which have many, many more bones than the adult because they're still in the stage of development. Each of their bones are made of individual components. It is certainly difficult to deal with the recovery of the remains of a subadult since there are multiple bones. When you're in a wooded environment, of course, that area of search becomes much more difficult in trying. So in looking at the recovery, it looked to be fairly good. One of the things I noticed that I did not see in the report or dealing with the investigation is trying to determine the exact location of where that body may have initially been placed. This is something that I normally do on a regular basis because in dealing with skeletal remains that are outdoors and which they may have been exposed to carnivore scavenging, the bones may be spread from the actual area where that body actually was placed or that body may have decomposed. And it's very important to try to locate that area of decomposition.
Why is it important to find the exact location?
Because when we want to define that area, that is where typically as the body decomposes, we may find much of the evidence related to not only the decomposition of the body, but various types of trace evidence. For example, if a body had been shot, if the bullet's contained within the body, as that body decomposes, that bullet will basically drop down through the body if it's not embedded in the bone and will work its way into the soil. Teeth, typically the anterior teeth that are single rooted as they fall out as a result of the ligaments within the dental arcade decompose. The front teeth many times will fall out when that skull is moved. And if there's any other trace evidence such as fibers, clothing, that is typically located and left at that scene. And so we also want to determine not only that evidence or to find that evidence, but it gives us a better idea where that body may have been initially placed that can help us in the investigation.
What could you have done? What could investigators have done to look for that? How would they find that? I don't understand.
In looking for those areas, typically, again, if you have a skeleton that has been dispersed, the area where that body initially...
Let me object and ask for voir dire on the issue of whether can we approach? I need to make a...
Judge, I would object.
Yes, you may approach.
My goodness.
What would you look for to try and determine where the initial deposit site was?
What we would look for is areas where you have evidence of soil staining as a result of the decompositional fluids leaching out into the soil. It will actually change the consistency of the soil. It can change the vegetation by either increasing some of the vegetative growth that feed on some of this, and it will also kill some of the vegetative growth as a result of these fluids smothering. We will also see evidence if it is during the time of year when insects are prevalent. Carrion insects basically will feed and reproduce in that area, and their remains, such as the puparial cases, some of the insects that die during that process or become trapped in the fluids, basically will be found in that area of the soil. And so we look for these environmental changes that tell us that a decompositional event had occurred.
Okay. And did you see any photographs indicating any soil change throughout the scene?
I didn't see any.
Okay. And we don't know if they actually look for that, but you certainly just didn't see any evidence in the photographs.
I didn't see anything in the report that noted that.
And would that be something that an anthropologist would note in their report?
I would hope they would.
Okay. Now, do you have any experience in finding remains with duct tape?
Yes, I've had numerous cases.
Okay. And what are some of the aspects that you take into consideration when looking at remains that may or may not have had duct tape, either to package them or to bound the victim?
I've looked at numerous cases in which the body has been bound in various ways, everything from wire, cloth, and those cases in which duct tape or other similar types of tapes have been employed primarily to bind the hands or to bind the head or the facial area. In looking at those types of cases and looking at the binding itself, when we have cases in which the body still has soft tissue on them and have begun earlier stages of the decay, we look at the positioning of the tape on the body to try to say exactly where that tape was actually bound to the body. And when we have cases when the body has basically undergone mummification, we get a very good idea of where the tape is because basically it is attached still to the mummified tissues. In the cases of skeletalized remains that undergo, or basically a body that undergoes decomposition, as a result of decomposition, basically that will affect the adherence of that tape.
Oh no.
And so one...
I don't believe we do, Judge.
Folks, approach the sidebar and cut the comments out. All right, Mr. Ashton, would you make your objection and
Let's
So we can go
go.
through it by the numbers.
Yes, sir. The objection is that the opinion that is being offered by the witness at this time is not contained in his report of February 21st, 2011, which was provided pursuant to the court order, which specified that any opinion that the witness was going to give must be included in the, just a moment, I want to try to quote it, had to be included in the report, as well as the factual basis for that opinion. There is no opinion in this report that references to duct tape. It is mentioned as a fact of the case, but there is no opinion that references any interpretation of the duct tape or any background information, as the witness has just discussed, about duct tape in other cases.
Mr. Baez?
Our position is, and our clear understanding of what the court's order was, is that if it was not submitted in the report or included in the witness's deposition, it would be precluded from trial.
Mr. Baez, pull out the court's order and read that portion
Oh,
that you were talking about.
shit. Oh, he mad. He big mad.
And while you're trying to find that, let me ask the doctor some questions. Dr. Rodriguez, what opinion you were about to express dealing with the duct tape?
In reference to this particular case, Your Honor?
Yes, sir.
That the positioning of the duct tape, as it was found, you can see in the photos there at the scene and the medical examiner's office that the duct tape is in two different positions. In a completely skeletalized rooms, unless it is in a buried context, one cannot make a absolute finding as to the exact positioning of a duct tape as it is lost, its effectiveness and stickiness. One cannot make a determination as to the restriction of that duct tape, and certainly in decomposed remains in which they have skeletalized the soft tissue to which that duct tape was attached, and the movement of those remains by animals basically precludes anyone from making any scientific conclusion as to the actual position of that duct tape, whether it was around the areas of the eyes, did it cover the areas of the nose and the mouth, did it just cover the areas of the mouth. In cases that I have had, have only been able to conclude the actual positioning of that duct tape in the case of a burial in which basically it is held in context by the soil, or in a mummified body in which the soft tissues basically have dried out and the duct tape is still adhering.
Doctor, when did you formulate that opinion that you just shared with us?
Early on when I saw the pictures.
Okay. Specifically, what do you mean by early on?
When I received the first pictures from Mr. Baez.
Okay. I don't know the date, Doctor. So
the photographs were given to me earlier this year, right prior to my report, which was dated February 21st.
Was there any particular reason why you did not include that portion that you just told us about in your report, sir?
I didn't mention it because it was a non-issue. Because in looking at these types of cases, there's no scenario where you can make a definitive answer. And so basically I wasn't asked at that time anything about the duct tape. It was just something that I had noted in my examination.
Okay. You noted it in your examination, but you did not include it in your report.
That's correct, sir.
Okay. Did you share that opinion with anyone on the defense team?
I did.
Who?
Mr. Baez.
When?
It was at one of the telephone conversations that we had after my report.
Was it in January or February of 2011?
I believe it was February of 2007.
Were you ever informed by the defense team or Mr. Baez in particular of this court's order requiring all opinions that experts are to give in this case to be placed into their reports?
I was not aware of that, sir.
Okay. Were you ever shown the copy of this court's order or informed of this court's order, the one that I've just mentioned, about experts being required to put all opinions that they will testify to within a written report, or face the possibility of having that opinion not being given in court?
No, sir, I was not made aware of that.
Okay. So Mr. Baez never informed you of this court's order?
That's correct.
Okay. Thank you, Dr. Rodriguez.
On those topics.
Go ahead.
Dr. Rodriguez, do you recall getting some emails from me just before you were asking you to submit a report?
That's correct.
And if you can recall, or can you tell the court if I had informed you that the court issued an order requiring all experts to issue reports expressing all of their opinions?
Yes.
Okay. And the communication that you and I had on this topic was via those emails, correct?
That's correct.
Okay. And when we met 2 nights ago, did we not?
We did.
Okay. And was that determination made that is something that we wanted to have you testify about? Or was it prior to that?
It was at that time.
Okay. And was that as a result to rebut what Dr. Warren had, well, let me rephrase that. Was that Do you know if this was in an attempt to rebut what we thought was testimony that was not true?
I was informed at that meeting about the superimposition. That was the first I heard about the superimposition done by Dr. Warren.
And do you have an opinion as to what that if a forensic anthropologist should do a superimposition?
That's correct.
Okay, what is that opinion?
In doing a superimposition is typically used to provide some type of tentative ID, basically identifying a victim by superimposing a skull over a photograph of the victim. Utilizing it to show a positioning of a duct tape and skeletalized remains is unheard of as far as I am concerned, because there is no way scientifically that you can show where that duct tape was. Basically, you can take that duct tape and you can reposition it anywhere on the body because you have skeletalized remains. It has been moved by animals. Therefore, even I, as a practicing forensic anthropologist, all I could say is there's duct tape in association that was most likely somewhere around the head. I cannot actually tell the position of it. I would be stepping off of scientific foundation if I were to do so.
Okay. Your Honor, the issue of all of this, when the court issued its order, I informed all of our experts via email, clearly expressing that we needed reports from them because originally we had not asked them to do so. And that all opinions that they were going to testify to should be included in the reports. Furthermore, I informed them that they had a deadline and that if that deadline was not met, that I would suffer dire consequences. You may recall that not only was I sanctioned, we were dead set on making all of the deadlines in which we did. From the time that I asked Dr. Rodriguez to write his report until the time he actually wrote it, it was a matter of days. I believe the court gave us 20 days or something like that, maybe a little more. I'm not exactly certain. This was a very difficult task for us to do, considering that all of our experts are extremely busy, that have multiple caseloads, and of course, the time constraints that were placed upon us. Furthermore, when we were never given this video superimposition during the photo CDs that the state had.
I'm not concerned about the superimposition.
Well, that's what I'm trying to get to, Judge.
Well,
what happened was we did not anticipate this testimony from Dr. Warren. It occurred when I met with my witness. I expressed and asked him for opinions on those, and that's what he's rendering. So
the doctor is mistaken or misinformed when he says he told you this in January or February of 2011. That's what you're saying?
I'm not saying that. But I can tell you this. We've discussed numerous aspects of this case, and there are numerous aspects that are not included in his report, nor will he testify to. So, I mean, to sit there and ask him, everything you told me, make sure you put in your report. I don't think that's reasonable. What is not reasonable as well, Judge, is that an important witness on a case like this should have been deposed. They chose not to, and your order says, and I will read as instructed, opinions that are not expressed in a written report or at depositions taken during the discovery will not be allowed at trial. I asked during a status hearing, what if they choose to not take someone's deposition? That's going to limit these people's testimony. It's going to create due process issues. And every bit of testimony is important, as is this. And I don't have Mr. Ashton's exact quote, but he claimed that they were going to take the depositions, but that this wasn't going to be some kind of trick that we were going to play with the reports. My response to that was something along the lines of, no one's playing games here, just that if they're going, and it's hard for me to make representations without the exact recollection, Judge. But my understanding and the purpose I brought this up was they were going to try and play a pull a fast one by saying, well, it's not in the report, that's it. Why should I take the deposition and then allow them to testify about more things? Do we have to, in a unique situation where the court has ordered something, now start taking depositions of our own witnesses? I sat in hundreds of depositions in this case, not because I wanted to, but because it was my responsibility to do so. And I have also taken depositions while this trial is pending. If this is an issue so concerned by the state as to make sure that they know everything that this witness may or may not testify to, they should exercise what tools are given to them and take the depositions and do the work.
Well, Mr. Byers, I want to ask you the same question I asked you earlier at the sidebar. What you're basically saying, sir, is that you can pick which court orders you comply with and which court orders you don't comply with. And that's not going to happen here.
I couldn't disagree with you more, Your Honor.
Well, Mr. Baez, to be quite frank, both sides have engaged in what I call game playing. Okay? And this is not a game. And the reason the order was entered in the first place was because both sides were engaged in some form of it at some time. And the reason the order was entered is because I did not want to be at the position I am currently in now. Is that we have experts with no opinions, major opinions that are not contained in their reports. And the easy thing is if a report comes about or if opinion comes about, you disclose it. It's not hard to do, Mr. Baez. It is quite easy to do, even if it happens at the last minute. So here am I faced with what is the remedy? It's quite ironic that we were scheduled to be here at 8:30 this morning to talk about a possible violation of the rule of sequestration. So you go back, you review the cases. And all of the cases seem to say that exclusion of the witness from testifying is a very extreme and harsh rule that is not to be done except in the most aggravated situations. And but they list a couple of other things that you can do. It appears to me that this was quite intentional. This was not some inadvertent slip. This was not some sub-issue of a major issue. It was not inadvertent.
Like me at the bar last night with
The question
the
is whether or
fighting
not
lady.
Ms. Anthony should be punished as a result of this. The case law seems to indicate the following: contempt, an instruction to the jury concerning the violation that has occurred, and let them use it in judging the credibility or believability. So what other opinions is this witness going to give that has not been disclosed in his report?
I will also.
Well, this is what I'm going to do. What other witnesses you have available for the day?
We have Dr. Spitz as well.
Okay, this is what we're going to do. We're going to stop today at 1 o'clock. This witness is going to step down. You can take his deposition this afternoon, and he will testify one day next week, Monday. I would entertain a possible instruction if the state wants to draft one about this violation, and I would decide whether or not I will do it. I will reserve the decision whether or not I should proceed to contempt proceedings at the conclusion of this trial.
I would request that the court also look at the answer filed by the defense, where I clearly laid out that Dr. Rodriguez would be called also to rebut any issues raised by the prosecution in trial. This does fall under that category. And
Mr. Baez, this is not my first rodeo. I'm rodeo rep. And let me say this, sir.
Holy.
I've tried one or two cases as a lawyer. And there was a case that I tried called the case of the state of Florida versus Judy Buenano. At the conclusion of the defense's opening statement, and after the first 10 questions that the defense asked in cross-examination, I found myself in a boat without a paddle.
Oh.
Because they raised the issue that you could not tell that they were raising up until the time they asked certain questions. And at that noon recess, I asked my investigator to find certain things out. By 4 o'clock that afternoon, my investigator had located about 4 or 5 additional expert witnesses. I talked to them that night. The next morning in court, I filed a supplemental discovery of those witnesses, and I set them all up for depositions the following evening, so the defense would have an opportunity to take those witnesses' depositions to determine what they would testify to. So the defendant would not be surprised. All my order simply tried to do was to give both sides an opportunity to know what each expert would testify to so they could prepare. So we would not have no gotcha moments where someone would be caught unprepared. So what we would do is we will take a 10-minute recess, and Dr. Rodriguez be prepared to give a deposition this afternoon at 1 o'clock. And then we can ferret out all of this. But let me say this. lightning does not strike twice in the same place. Even though the case law says you can't be punished by exclusion the first time, if there are other opinions that you know that he's going to give, they need to be laid out. Because I am not making any promises or warranties about what I would do if it happens a second time with this witness.
We would like to place the state on notice that we're going to take our own experts' depositions at the conclusion of today. If they wish to be present, they can be present. And
Well, you don't have to take your own expert's deposition. I'm making him available for the state to take his deposition. It would be totally unfair to Ms. Anthony to have his testimony excluded on this critical issue. But we will deal with the after effects afterwards, and that's the remedy that I have chosen to give. We'll be in recess until 5 minutes to the hour.
Everything about this comment that I just highlighted for you guys, this is where we get Brady issues.
SPITZ.
You may proceed, Mr.
Morning, Dr. Spitz. Could you tell us, sir, a little bit about just who you are? What is your profession, sir?
Wait,
I'm a medical doctor, and I'm a forensic pathologist.
So Spitz is like the greatest of the greatest. We all know that. One of them, at least. Casey Anthony trial. I need to figure out what day that was because I want to see if essentially this playlist that I'm watching doesn't include a lot of those like sidebar moments. And if there was any more of that conversation to be heard for the trial, for the jury rather, for us. I know what I'm doing, you guys. I totally know what I'm doing. Then I wanted to hear it. I am looking. All right, I'm going to press play. Until then.
I know it may take a little while, but I do want to go through your academic training and background. Would you tell me, sir, where you went to medical school?
He
and when?
worked with Jesus.
I went to
he's
medical
that
school
old.
at the University of Geneva, Switzerland, School of Medicine, from 1946 to 1950.
Okay, I want to listen
And
to
then
the next
transferred
thing.
to the Hebrew University Hadassah Medical School in Jerusalem at that time.
Okay, who will be the defense's first witness for today? And Mr. Ashton, you indicated that there may be an issue with Dr. Rodriguez.
Yes. The first issue is the court had left the issue of a sanctions package as to this witness for later consideration. We did take his deposition from 1:45 to approximately 3:45 on Saturday. I just received a transcript of the deposition yesterday. I've read through it once. I would like to read through it again in preparation for cross-examination. So number one, I would ask that this witness not be called immediately because obviously I need time to consider what he said. There is one particular area that he proposes to give an opinion that the court would need to review the transcript that I don't believe he is qualified to give. Specifically, just to summarize it quickly, he proposes to give an opinion that other people can't distinguish human decomposition from other odors. And to very briefly state it, after some considerable questioning, he finally came down to say essentially that it was just based on his personal experience rather than any studies or scientific literature. But I would like for this witness not to be called first because obviously I need to have time to prepare for cross-examination from this lengthy deposition that we took and have a hearing on that one issue, which because of the violation of the discovery order, obviously I was not able to do. The one opinion I just mentioned is an opinion that was not contained in his original report. So it is new. There are other new opinions as well that I may be able to deal with on the fly, but I would just request that counsel not be permitted to call this witness until I've had at least half a day or at least some kind of break to digest the deposition and prepare for cross-examination because of the discovery violation. The other issue that I mentioned at counsel table is at sidebar is as to a witness, Mr. Eichenblum. Just so the court has this, and I don't necessarily want to argue sanctions on this right now, but I just want the court to know it's coming. We received a half a page report from Dr. Eichenblum pursuant to the court's order that essentially contained no opinions or conclusions of any kind. Mr. Eichenblum showed up Friday outside and prompting us to question counsel about what he was here for, since his report indicated nothing, essentially. Yesterday,
Hi.
I was, and Mr. Eichenblum showed up at my office yesterday afternoon for a potential deposition, but I sent him away because without a report, I have no way of deposing him. I received a report, which is 2 pages in length, and a 45-slide PowerPoint presentation yesterday from counsel. I'm providing the court with both. I am willing to depose Mr. Eichenblum Tuesday evening and to do as much as I can. I will be preparing a sanctions package for the court because, again, this is, I believe, another deliberate violation of the court's order.
Yeah,
I'm gonna,
but you
may I approach?
fucking did it
You may.
too. So
What is
I'd be
Dr.
careful, buddy.
Eichenblum's field of expertise?
I think he has phrased it as trace DNA and trace evidence or crime scene evidence, something general in that sense. It's in the report. He is proposing to give a number of opinions on, I guess I should say, the interpretation of negative DNA evidence, but it's reflected in his report. Again, I'm not prepared to argue the issue now because obviously I haven't deposed him yet. I need to do that, and I will do that on Tuesday at 5:30. Should the defense produce him.
This shit is bonkers.
So those are my requests at this point, is that Dr. Rodriguez not be permitted to testify until I've had time to review and prepare for cross-examination because of the last-minute nature, and that Mr. Eichenblum be ordered to appear. I will be presenting the court with additional requests for sanctions to alleviate the prejudice, but at this point, those are my initial requests.
So there's that.
Under Rule 3.220, the prosecutor is afforded the right to take depositions in a case. This is a capital case for which he is prosecuting and seeking the ultimate penalty. The witnesses in question were listed timely and were ordered by this court to issue a report under time constraints. I immediately instructed each witness to put together something as quickly as possible.
Just write something
Despite
down.
having,
Write your name with a header and a footer. Damn, kids.
A proper amount of time to ensure that every single opinion that they have that may come up during the course of trial, which is clearly an unscripted event, would allow them to put something together to completely comply with the court's order. The court's order under Section 4, Section 4, Paragraph 4 states opinions not expressed in a written report or, emphasis added, at deposition taken during discovery will not be permitted at trial. The prosecutor in this case has attempted to narrow the scope of the testimony of these expert witnesses by intentionally refusing to take their depositions. I say this is an intentional act because it is clear that there was a sufficient time period for Mr. Ashton to coordinate these witnesses for depositions, set them, and conduct them. This package that he claims to put together or want to put together can easily be done for him, as the state has violated this order itself on two occasions.
Amanda,
one with
that's
Dr. Rickenbach,
awesome.
which was taken at sidebar. The objection was sustained because he wanted to elicit testimony outside of his reports or deposition. And it was quickly moved on with no threats of any sanctions and no threats of being held in contempt of court. Furthermore, when the FBI, with the late disclosure of photographs on the morning of trial, that too was addressed and moved on. I think that the court has made it clear that this is not a game.
I hate right fighters. I hate people who are just going to fight to be right and hold on forever. Like, shut up, bro. You're hanging yourself with the rope that you have right now. Like, shut the hell up and fix this.
And that gamesmanship has been exercised by both sides. And I think that this is nothing but a clear exercise of gamesmanship that is carried on from Mr. Ashton from the very beginning. He is a skilled and experienced prosecutor that knows that with expert witnesses, you should take their deposition. I would venture a guess to say that he has never had a trial where he has just completely ignored expert depositions, especially those such as important as these. But yet he was armed with a court order which he thought he could play games with and use as a sword and both as a shield by completely and intentionally ignoring his responsibilities as a prosecutor to go forward and fail to not take a deposition. As it pertains to Dr. Rodriguez, the remedy under the law is to give the prosecutor time to take his deposition. These things occur on many occasions, and these are really minor issues. The duct tape opinion that Dr. Rodriguez is simply going to express is that there's no scientific basis to render an opinion as to where a piece of duct tape is when it is on a surface deposit site, because there are too many things that can alter the location of this duct tape. This is, aside from being common sense, this is being testified by someone who has the experience to do so. As it pertains to Mr. Eichenboom, we have attempted to, because of the failure of taking his deposition and what he might be able to testify to, one of the issues that we originally wished for him to testify about is the aspects of DNA. Low copy number DNA, degradation of DNA, all of which was given notice to the state, not only through my response in the pleadings to the court, but this is a common issue that the state is on notice of. Their claims that, and their potential arguments that the reason there's no DNA on these items is because of the elements, knowing full well that that could degrade certain DNA, but there still should be DNA on these items, and one can obviously and potentially testify to that. Some of the issues that came up with this case have come up recently, and I because not too many arguments were laid forth as it relates to Mr. Eichenboom, I'll keep my comments to a minimum. Mr. Eichenboom, as I expressed in open court Saturday, that we will be taking our deposition. We will be wishing to exercise all of our depositions for any potential experts where the state has failed to do so. I asked and instructed Mr. Eichenboom to show up to the state attorney's office on Saturday afternoon, which he did, and he was turned away.
Oh, that's bullshit.
Specifically
that is
by Mr.
bullshit.
Ashton, not by an associate, not by a secretary. Mr. Ashton told him to go away. Upon doing that, I instructed Mr. Eichenboom to prepare a report and to ensure and to do it immediately, of which he did. It was sent to me, and I forwarded it on to Mr. Ashton on Saturday evening, as well as any potential demonstrative aids for which he may find useful in explaining his testimony. That was also disclosed and turned over to him immediately. All of this is stuff, and all of this is information that just merely explains DNA and its processes, and that most of which I'm certain that Mr. Ashton, with his experience, would certainly be aware of and would need very little preparation in light of.
And we know the outcome.
Now,
and I'm not going to say it, but
I think, as to Mr. Ashton's argument about wanting extra time to now review depositions, well, that's not a very good argument, considering the fact that for several months, approximately 7 or 8 months, he sat and decided not to take a deposition and not to prepare for this trial as needed. So because of his intentional omission, he now wants to delay this process. He wants to delay our time, the court's time, the jury's time, for something for which
he needs to
is his professional responsibility to carry out. The order, well, the order is fairly clear. And I read this order to include.
I also want to provide some context. Let me make sure that you guys can see me on the vertical stream. Okay. So to provide some context, all of this shit that we watched with them, the contempt being thrown around, blah, 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 the stream before this, before Dr. Spitz, that happened on a Saturday. So that judge had to go out of the way to have the building open, to have the caterers present, to have activities planned so that the jurors could get to the courthouse on a Saturday and get back, and then have plans with their families. And the fact that they had to stop deliberations because of the tomfuckery taking place is mind-blowing. Jose cost I don't even want to boggle my mind to guess how much money he wasted the taxpayers just on this. And I get it. It's both sides. Both sides are doing it. And unfortunately, Jose overdid it. He overplayed his cards. So I think there was a lot of anger from the judge specifically for that reason. Everyone had taken out time to come in on a Saturday to work. And that shit happened.
Two aspects
This
of the
is on a
discovery
Monday
process. One, which is written reports, and the other, which is deposition. The goal of this court was to prevent any gotchas. I specifically noticed that Mr. Ashton was intentionally omitting, or may omit, I should say, to prevent himself from taking these depositions, and I brought it up at a status hearing, and I warned the court that this may be an issue later on because the state is attempting to use this both as a sword and a shield. We did not intentionally look at this order and say we're going to disobey it. Just the mere thought of that disturbs me greatly. And it disturbs me that anyone would either A, make the accusation, or B, even assume it to be true. And I say that because I have labored on this cause daily, nightly, and it was made clear by the court to me that this court intended on issuing orders and enforcing them if need be. I see that even though the rules of discovery and the law does not compel us to ask experts to issue reports, this court ordered that. However, I think it is a severe due process violation to try and limit our testimony, limit our presentation of case, because a prosecutor decides on his own, without assistance or acknowledgement from the court, to omit his professional responsibility and to omit his duty to carry out and utilize those tools which are afforded to him under the rules of discovery, and then attempt to use that as some form of sanction. Okay, it's not bad enough that he wants to omit these responsibilities in the efforts of taking a human life. He wants to go after her lawyer too, and I think it is repulsive, and I think it is also not under the law. And shouldn't be dignified in any way, shape, or form by this court. He had a responsibility. He intentionally omitted that and neglected it. And he should not be allowed to come forth, not even at the 11th hour, at the strike of 12, and decide, okay, now I want to utilize something and do it in a manner that is, I don't want to use the word disingenuous, but to do it in a manner where it's unreasonable. It's unreasonable that he should think that Dr. Rodriguez would have opinions such as these. These are obvious opinions. These are obvious things that, these are obvious troubles with their case, and they know it. Thank you, sir. Unless the court has any questions, I have no further argument.
Nope. I'm going to ask both sides to turn around and look at that clock back there and tell me what time it is.
Ass whooping time?
And Mr. Baez.
9:26 is usually the order.
Okay. All right. Thank you. That shows that the two of you will never agree on anything and will never interpret anything the same way. That jury has been sitting back there for more than 25 minutes. Sergeant, what time did the jury arrive here this morning?
Been there for an hour, sir.
Okay. Henceforth and forevermore, all the attorneys are required to be here exactly at 8:30. So if you have any matters you need to take up, you will notify the court deputy. The court deputy will call me and we will take those up at that time. At 9 o'clock, we will start. And no more will we have this. This coming Saturday, we will work a full day.
Told you guys, told you. I knew it.
So be prepared to have witnesses here to work a full day this coming Saturday. The rules of criminal procedure lays out what is discoverable, but it does not take away from the power of the court to order additional discovery, restrict discovery, or set whatever timelines this court feels is necessary. I will call your attention to an order entitled Order Granting State's Motion for Clarification or to Compel Compliance with Order for Additional Discovery, which is dated December 10th, 2010. I'm not going to go into the history of why this particular order was issued, but this is the pertinent portions of that particular order. Where the experts have not prepared reports of examination of tests, both the state and the defense are required to provide the following information, which shall be filed with the clerk of the court in forms of written pleadings. The expert's curriculum vitae or qualifications of the expert, the expert's field of expertise or medical certainty, a statement of the specific subjects upon which the expert would testify and offer opinions, the substance of the facts to which the expert is expected to testify, and a summary of the expert's opinion and grounds for each opinions. That was done because there were a couple of reports that basically contain nothing. The court thought that that order cleared up the situation. Here we go again.
If you guys haven't liked this video, what are you guys even doing? Please like the video, subscribe. No shame at this point, none.
Yeah. On January 6, 2011, the court entered another order, order granting state's motion for sanctions and motion to compel. Again, there was some lack of understanding of what the court may have meant. A statement of the specific subjects upon which the expert would testify and offer opinions, the substance of the facts to which the expert is expected to testify, and a summary of the expert's opinions and the grounds for each opinions. Court gave out an example of what was submitted on behalf of Dr. Henry Lee. Court goes on in its order and says that the defense shall provide written reports to the state from all expert witnesses, which shall include the following information: a complete statement of opinions the witness will express, and the reason for those opinions, and any data or any information considered by the witness informing their opinions or conclusions. The court in those two orders required both the state and the defense to have expert witnesses list all opinions that they would give. The purpose of depositions are to expound upon those opinions. And as all lawyers know, there is an opportunity for sub-opinions once someone gives a main opinion that they may want to discuss. It has never been the intent by depositions to alleviate the responsibility, and that was not the intent of this court's order, to say, well, you could either take their depositions or the report. The orders are quite clear to me. This court does not make threats. This court simply applies the rules. When the state of Florida had an exhibit that they wanted to introduce, i.e. a demonstrative exhibit that was not given to the defense, that exhibit was excluded and the state was not allowed to utilize that exhibit. The court on Saturday indicated that it was put in a proverbial corner, not being able.
Please notice how many times he's going to point out Saturday. Saturday. They're pissed. They're pissed.
But to exclude these opinions by the defense. If you read all of the cases dealing with exclusion of evidence, particularly Dumas, Wright, Lott, Odom, and U.S. versus Hobbs, it frowns upon that because you punish the defendant. But what the Florida Supreme Court did not close the door on, if someone continues to repeatedly violate orders of the court, it leaves the door open, regardless of those severe due process considerations, that as the final ultimate sanction. There's never been a case where that final ultimate sanction has been imposed and upheld by a court that I know of. But one would surmise that if someone continuously violates a court order with impunity, whether or not the court would be left powerless or whether or not the Supreme Court will say, this is the case, despite the due process implications, where the ultimate sanction of exclusion would be proper. Yes, there have been gamesmanship in this particular case, and it is quite evident that there is a friction between attorneys. That is something that I guess the Florida Bar will deal with. And at the conclusion of this trial, this court will deal with violations which may or may not have occurred, but it is not proper for the court to deal with it now during the pendency of this very serious litigation. As to the request of the state to defer the testimony of Dr. Rodriguez, I will grant that request. Now, I've announced to both the state and the defense that we're going to have a short day on Wednesday. And that's because of me. And I've explained to the lawyers the reason behind it. Let me say this to both sides. If I was the state or the defense, I would make sure when we recess this afternoon that I would go through the reports of all my experts and make sure that their opinions were contained in the reports or depositions. As I explained to both sides, sub-opinions, as long as it's under that general area on minor things, those are going to come up either in recross or direct. You can't anticipate everything, but enough is enough. And both sides need to be forewarned that exclusion, even at the price of having to do it all over again, which I don't think I will have to do it all over again because of repeated violations. Exclusion may be the proper remedy if it continues. So,
Sir, yes, sir.
Who will be the defense's first witness?
Judge, our second witness that we had intended on calling was Richard Eichenboom. But if in light of that, we have to wait. We're in the process of picking up the third witness. It would take approximately 30 minutes to have her here.
Okay. Inform the jury that, and take them out since they've been locked up in that room for quite some time, that we will proceed at 10:25. Okay? The only thing I'm going to say is this, folks. I'm getting very, very close to starting this proceeding every morning at 8:30. And I know that would bring some problems. But at the same time, I've been trying to be accommodating with the work schedule for everyone. But I have a sequestered jury.
They did text her, sis. That
Who
person was also
live under
asked.
severe restrictions. And if y'all don't want to act professional, then I will work you real full days. And that will include reducing your lunch hours. And I try to give you an hour and a half because I realize you want to eat, relax, and sort of look over your notes. But all of this, folks, is going to stop, or you will be working some very fierce days. And so be prepared Saturday to go the whole day. Okay, we're in recess to 10:25.
Love, 10 out of 10. This was incredible.
Okay, you may be seated.
Wait, no, we can't. Oh.
Okay, let the record reflect that the defendant is present, along with counsel for the defendant, assistant state attorney, upon joint stipulation between the state.
And that's it for now. So that was fun, and that was wild. And hold on one second. Sorry, I really didn't want to belch into the microphone. Yeah, that was unique. Let's put it that way. New York, unique New York. They wouldn't have known, because that visitation, it wasn't, they were selecting to go to jury instead of having, they were selecting that instead of working. But knowing what I know now, after hearing a interview with the judge, I bet that after that happened, he accommodated the jurors on that issue. So they were like rapid fire solution finders. I loved them. So I am excited to come back tomorrow with Dr. Spitz and some more of the forensic experts. But yeah, I don't blame him, is what I meant. I don't blame him for being pissed that he brought in all these resources, which I have worked for the government. I understand what these resources are. I will never work for the government again. It's a bunch of red tape BS. I get what goes into putting up this sort of effort on a weekend. It's essentially unheard of to have these union workers brought in who aren't used to overtime, of course, they're going to be like, oh my God, yeah, of course. But it comes at an expense to the county and the state. So I get why he was pissed. I 100% understand. So, that was wild. And tomorrow I will be back here at 3:30. I want to thank my mods for always being ballers and helping me out with everything. And I want to thank everyone who supported the stream and who liked and subscribed. If you haven't done that yet, please make sure to do that before you leave. And I will be back tomorrow on January 2nd. Hooray. Okay, guys, you guys behave and make wise choices tonight. And I'll see you at 3:30 p.m. Eastern tomorrow. Peace.